May
Yes.
your lordship's leave to file amendment with the server copy of the order.
Date of the order?
21st of March.
Yes.
Lord, may I have your lordship's kind leave, Lord,
Lord,
to
may I
file the appeal without the certificate. This is from Jalpaiguri Circuit Bench, Lord. Order is passed on 10th. Lord, the server copy uploaded on 12th. The 13th was the only working day left, so I could not approach the circuit bench. Now the circuit bench, since not in motion, your lordship would have the determination.
Milord,
Lord, may it appear on, Lord, there's some urgency.
File it, sir.
Milord, may I have
Even
leave,
before it is filed, how to list it?
leave to file the mandamus appeal on 20th March it was.
Yes,
May I have my lord's kind leave?
same request.
My lord, to file without the certified copy. 13th April is the my lord, date of the order. My lord.
Very good.
Similar prayer, my lord, 21st of March was the date of the order.
May I have your lordship's leave,
Lord,
my lord, to mention a matter, my lord. I was beseeching your lordship to list the
First,
matter.
let all this,
Leave, lordship.
leave to file.
Passed on 10th April, Lordship. Lord, leave to file, my Lord. This is a DRT matter, my Lord. The, I've been, my Lord, my Lord, applied for the certified copy, my Lord. For 1 month, they are unable to trace the file.
11th April.
11th. Yes,
My lord, may I have your lordship's leave to
for
mention a matter?
upgradation.
Not for upgradation, my lord. It's for prayer for listing of the contempt application, my lord.
Please, please.
My lord, I have mentioned earlier on 2 occasions also, my lord.
What to do? See, we have, in fact, today,
My lord, this is yet to be listed since the month of December 2022, my lord.
let us. Against which order? Which
My lord, this is
division
a
bench?
contempt application, my lord, arising out of the violation of a series of orders passed by learned 13th additional district judge at Alipur, my lord. My lord, I had filed this application in the month of December 2022, despite having mentioned before different benches of this court. Unfortunately, my lord, the matter is yet
No,
to
no.
see the light of the day.
ACO. Same letter, I issued some direction. You don't remember that letter.
My lord, previously the determination
yes,
was with
I-
Justice Dasgupta, my lord.
You give the letter today.
My lord, I have
I
already given the letter. I have already given
No,
this.
no, I remember, he doesn't remember what to do. Please give the letter.
I
Let
have
us-
already, my lord, handed over the slip to
Yes,
him.
yes.
I'm extremely grateful, my lord.
May I have my lord's kind leave to mention a matter, my lord. I had mentioned this matter on Thursday.
Hmm.
Lord, your lordships had directed us to deposit a sum. Today is the last date for making that deposit. My lord, provided the department, my lord, immediately what we pay was to be, my lord, credited to the
Yes,
electronic
yes,
credit
we
ledger.
remember.
My lord, the matter was supposed to be, my lord, listed today. Unfortunately, it is
It
not
will
in the
come
list
tomorrow. It will come tomorrow.
tomorrow. I'm
Well,
deeply obliged.
may I be permitted to mention one matter?
I'm very
my lord?
deeply obliged.
This is a matter where the Howrah court lawyers were beaten up by the atrocity of the police authority. And this honorable court, the then Chief Justice, took the matter as on his own motion, my lord. A writ petition was initiated. The commissioner of inquiry was appointed by Honorable Justice Koldanjit Sengupta. Report was filed, my lord. But the state government is not implementing in any of the direction given by the state government.
I think the matter was listed last week.
No, my lord.
No.
No. My lord,
Let
let
us
this
see,
one-
at
there is
least-
some priority, my lord, with regard to the
218 matters are
that I
there
know, my
today.
lord, because it is the involvement of the lawyers, my lord.
We will consider. Please give.
Lordship, may I be
May I have
I'm grateful.
permission, my lord? My lord, it is a appeal matter, my lord. It is appeared in the combined list, 3rd April, my lord. My lord, yeah.
My lord, this is an upgradation
Petition,
petition. It's appeared in this 615 in monthly list.
you want to upgrade.
I upgrade.
Let us finish this. You wait for a week.
may I pay for inclusion of an intra-court appeal, my Lord?
Fresh matter?
Lordship,
It's a fresh matter?
fresh matter, Lordship, it has not been listed, my Lord. Appeal was filed on 8th June 2020.
Yes, yes, you give.
My lord,
Kindly, my Lord, on the. If you file the appeal.
Leave
may I have the
Point number 738 of the monthly combined. The
What to-
restoration of the electricity.
electricity, please give.
my lord, may I
My
be
lord,
permitted?
may I have your lordship's leave, let
Hmm.
to mention for upgradation, like, these 2 matters I am not mentioning, like, I have, if your lordship permits me, I can hand over the slaves.
Give the.
And my lord, so far, this matter is concerned, my lord, this was appearing under the heading special fixed matter.
Hmm.
This is a case, my lord, where the young boy was murdered by police, my lord, in police custody, my lord.
Hmm.
My lord, we are seeking independent investigation, my lord. My lord, this matter was appearing under the heading special, my lord, annex the list also, my lord. On 16th March, it was directed to be listed on 12th May. It is appearing in the 12th May, but under different heading. But it needs to be taken up early. Otherwise, the
12th May.
matter will be infectious.
12th May.
12th May. I'm sorry, 12th April. I'm
12th April.
I'm sorry.
12th April.
I'm sorry.
You give the number.
My lord,
Kindly let this is the
may I have your lordship's kind leave to mention item 636. My lord, the difficulty is that the whole corrupt practice of the panchayat has been challenged. The panchayat election is ensuing very shortly. My lord, unless this repetition is taken up, it becomes infructuous when the
You give the letter.
May I have my lord's leave to mention, my lord, I had bought an asset under the bankruptcy and insolvency code from the liquidation.
Very good.
He had made a liquidation sale, and my lord, I paid the entire money. And now when I want the electricity, DVC is telling me you have to pay the dues of the previous consumer, which is not there. He has to get it from the liquidation code. From the liquidator, he has to file his claim and get it. So I filed a writ petition.
All claims stand extinguished after the insolvency proceedings are.
I filed a writ petition.
You please give the number.
And Millard, today everything is ready, but without electricity, Millard, I have to pay 300 workers' wages every day, and I'm not getting electricity.
Let us see.
Millard, kindly, Millard, it is appearing as very low down in the list. Kindly,
What to do?
Millard, I'll tell you, Lordship, why. You can ask me, why don't you go for contempt? If I file a contempt before the learned single judge, he said, 4 weeks' time, you get to restore, or you get a stay. They moved the appellate court, no stay was granted. I can understand if a stay was granted. In February, they moved, no stay. After that, adjournment after adjournment, and I don't get my electricity.
We'll consider.
I given the mentioning slip, and the 2 orders of February. The last order, counsel for the appellant asked for adjournment.
You
Adjournment
please
granted.
pin up those orders and give it along
Yes.
with the slip. You staple and.
I'll staple and give it.
No, your junior will do that.
Your lordship's officer has a staple. It's very.
Public interest litigation, my lord, where the state has been directed to file a report. This is pertaining to the Medical Services Act, my lord, where, my lord, the state is under.
Please wait for a week.
Very well, my lord. I'm putting in the
Put
slip,
in
my
the
lord.
slip, let us see.
My lord,
May I
I
be
am
permitted
permitted
to
to
mention-
mention one matter for upgradation in the list, my lord.
Next
This is
week.
the appeal, my lord.
What to do? 200 matters we can't.
My lord, this is running in the daily list, my lord. This is item number 197 in daily list, my lord.
Please wait, let us progress today.
My lord, I am also for inclusion of a intra-court appeal filed on 1st March.
Fresh
2020.
matter?
Fresh matter filed on 1st March, 1 month ago. my lord.
Fresh matter automatically.
May I permit to mention, my lord, fresh matter where
Fresh
the
matter.
petitioner was severely beaten by the police in the police station, my lord. I lodged a complaint to the superior authority, no step was taken.
Fresh matter, it will come.
May I have your lordship's kind leave, my lord, to mention, my lord, a matter for inclusion, my lord. This was directed to be, my lord, to appear, my lord, in the monthly list of March. So, my lord, it did not appear. So,
Lordship,
praying
if
for
I were to
inclusion,
mention
my
the matter, this is for listing of an appeal, Lordship. There's an urgency in the matter.
It's a fresh
That-
matter?
No, Lordship, this was already heard on 22nd March and interim protection was granted to the appellants, that is us. So Lordship, it is ceasing on 19th April. So Lordship may kindly fix this matter on
Oh,
19th April. for
interim order is only after 19th April.
Yes, Lordship.
So you, for
I have
extension
prepared the.
My lord, I am,
extension of interim order.
my lord, I
And you
am,
mentioned that.
Yes, Lordship, it is mentioned.
You note down, yes, you note down extension of interim order.
my lord, I am mentioning the matter item number 491, 2023 for the electricity connection. Please.
Lordship may be permitted to mention one matter. It actually, Lordship, today's item number 4, it is actually regarding a service scam of Uttarpada municipality.
Let it reach.
Now, Lordship, these two are for Bhadreshwar and Rishira. So let these be heard together because
The matter be called, will you please be here.
as your Lordship. my
Item
lord.
4,
As your Lordship.
My lord,
May I-
may I pray for your lordship's kind leave to mention a matter for inclusion? My lord, we have taken out an application for contempt in connection with an arrest, my lord, carried out in violation of section 41A. My lord, the Honorable Supreme Court in Arnesh Kumar, my lord, had laid down guidelines, my lord, therein,
contempt of which order?
my lord,
Contempt of the Supreme Court.
yes, your lordship. Yes, your lordship. Lordship, leave was also given in the Arnesh Kumar judgment to initiate contempt before the High Court having.
Yes, Mr.
Lord, may I mention one matter, my lord? Your lordship passed a judgment dated 11th of April relating to the illegal functioning of the livestock cattle market. So, my lord, your lordship gave various direction in that order. My lord, I am praying for addition of 1 or 2 observation in that.
Now it can't be done unless you file an application or review. or something. We can't do it under the caption to be mentioned. because order has already been
Only
uploaded.
one thing, if it can be added, your lordship is given direction for functioning of the all the markets in accordance
No,
with the
if you want
rules.
to file a review, you file a review.
No, my lord, all that I am requesting, if it, the timeline can be given in that order.
Then you file an application, we will consider that application.
I have a lordship leave to mention, my lord, for implementation of your lordship order dated, my lord,
Which is the division bench?
division bench order of this division bench order.
Which, who are the honorable judges?
Yes, pardon, my lord.
কোন judges?
Oh, judges Prakash Kumar Srivastava, Chief Justice, and Rajesh Bharadwaj, Chief.
Then the contempt has to come before a division bench to which Justice Rajshri Bharadwaj is a party. You give a letter to the secretary. I will assign.
This is not a matter related to contempt, my lord.
Yes.
This is a directions wherein my this lordship was directed to dispose this writ petition within such and such time. But our persistent endeavor, the writ petition not yet listed, but not yet taken up for hearing, and already 3 months lapsed. And my other side is also here, State Bank.
No, it is not in the monthly list.
It is running as a contempt application in the Friday daily list of before the single bench of Honorable Justice.
No, contempt application has to come before a division bench to which at least one of the.
No, my submission is the split up of this case so that these directions wherein your lordship.
Give the letter. We'll see whether, I don't think so it can be split up. You give the letter, let us.
May I
My
be
lord,
permitted to
kindly
mention
go
one matter?
through the order, my lord, kindly. Kindly go through the order, my lord, kindly.
We'll do that.
For upgradation, your lordship, item number 198. I am for the private respondent. I am suffering an interim order, your lordship.
Please wait.
My
Let
lord,
us
may I
start the
be
list. It's
permitted-
already 10:45.
My lord, may I be permitted to mention one new motion bill for upgradation? It is item 637. It's a new motion bill.
Why new motion has gone to 6:30?
My lord, in the monthly list, my lord, kindly see. In the monthly list of April.
May I mention one matter for inclusion in the
Inclusion. It is an adjourned matter.
No, not, and it was not yet taken up. It was filed and the number, it was in the monthly list of April, it first appeared, my lord. Subject to correction, my lord. Subject to correction.
We'll verify. It's only upgradation. This matter was appeared in the monthly list 3rd April as item so and so urgent here. You verify. Yes. He's gone already. Call the council. It has been adjourned at your request. Inclusion.
For inclusion.
Yes, please call the list.
Appellate side, daily list, item number 1.
My lord, my lord, appear on behalf of the petition, my lord. It is for non-prosecution.
Pardon?
Non-prosecution of this. I have instruction.
My lord, may I indicate, my lord?
None is present, case is adjourned.
My lord, I appear for the state respondent.
Letters have been written to the learned advocate on record by the petitioners, my lord, to withdraw this.
Withdraw the petition.
Lord, may I indicate certain facts, my lord?
What is the? It's a public interest litigation.
Yes, my lord.
Absolutely, my lord. The cause for this public interest litigation is forced pisciculture, my lord. Agricultural lands are converted into piscicultures, my lord. This like this, my lord, big plot of lands are filled up with waters. Or small landowners, they are bound. They cannot do anything when water enters their portion of land, my lord. Now, my lord, this honorable court was by order dated 1st of August 2022. This honorable court was pleased to direct the state respondent to ensure that the petitioners can carry on their agricultural activities. Lord, and directed the state respondents to file a report. Lord, further, my lord, the state respondents have filed a report, my lord, on. My lord, will kindly take my report. On 13 July 2022, my lord, the state has filed a report, Lord, acknowledging the problem
that it has said in the report that it has issued notices under 4C for violation of the for converting the wrongfully converting the nature of the land. Today, my lord, it appears that the petitioner has lost the charm of the writ petition, public interest litigation.
But forget it.
My lord,
But you proceed further with
absolutely,
that.
absolutely.
Yes,
My lord will, my lord
absolutely.
can, subject to my lord's kind approval, my lord, your lordship can dispose of the matter, directing the ADMLR to conclude the proceedings as taken up under the West Bengal Land Reforms Act.
There is a time frame within which it has to be done.
It is not there, my lord, it is not.
Well, it was immediately, so as soon as information is.
This
My lord,
public
difficult-
interest lit petition has been filed.
My lord, difficulty is, my lord, for the reason, my lord.
Well,
the
much
petitioner
doesn't
asked
lie
us
in
to-
his mouth, my lord, he does not
Direct
want
the
to prosecute it.
respondents to stop all illegal activities of the persons from converting agricultural land into fishery and to protect the agricultural lands.
Within a specified time. Notice দেখ না কি বলেছে।
The Honorable Division Bench on 1st of August 2022 directed the state authorities to ensure that no agricultural land in the concerned area is illegally converted for the purposes of fisheries/pisciculture. There was a direction also to file a report. The Block Land and Land Reforms Officer, Hon'ble had filed a report dated 13th July 2022, stating that notices under Section 4 capital C of the West Bengal Land Reforms Act 1955, dated 2nd May 2022 and 6th May 2022 have already been served among the major portions of the recorded riots of the plots in question, and wide publicity of the said notices have also been made in the notice boards of the local Gram Panchayat office and other government offices. The learned advocate appearing for the writ petitioner has filed a letter addressed to him dated 29th March 2023, purported to have been signed by the writ petitioners, one of whom has affixed his thumb impression, stating that they do not wish to proceed with the matter and seek for withdrawing the writ petition.
My lord, kindly have a look to next order also, my lord.
Pardon?
Have a look to next order, 8th of August.
The learned advocate appearing for the writ petitioner points out that on 8th of August 2022, the Honorable Division Bench has directed the state authorities to ensure that the owners of the cultivable lands are not restrained by any of the third parties in carrying out agricultural activities on their lands without any lawful reason. It is not clear as to why the writ petitioners seek to withdraw the writ petition at this juncture. In any event, we are not inclined to accept such a request for more than one reason. Firstly, because the state authorities have already initiated action and notices under Section 4 capital C of the West Bengal Land Reforms Act 1955 have been issued to the offenders. If that be the case, then the concerned authority who has issued notices should take up the matter and conclude the proceedings as expeditiously as possible. Therefore, we dispose of the writ petition by directing the sixth respondent.
This is quite a big problem. My lord will kindly direct the district magistrate to ensure that the proceedings are concluded by the competent authorities.
We direct the fourth respondent, the district magistrate, Purva Medinipur, to issue appropriate instructions to the competent authority under the Act to proceed further pursuant to the notices issued under Section 4 capital C of the Act. Conduct an inquiry, and if there has been any violation or illegal conversion of agricultural land for purposes of fishery or pisciculture, immediate action should be taken and the land should be restored to restored as agricultural lands. The district magistrate is directed to ensure that the competent authority under the act concludes the proceedings initiated under the West Bengal Land Reforms Act within a period of 45 days from the date of receipt of the server copy of this.
We remain grateful, my lord.
Grateful to my lord.
Next.
Item number 2.
Disposed of. My lord, disposed of. My lord. Grateful to.
Yes.
Appear for the respondent.
We have said 17th April only. It should come on 17th May. He says 17th May. No. The other day, nobody appeared for the.
Yes, my lord. Mylan friend appeared for CSC, my lord, and the petitioner also was represented.
No. Mr. Mukherjee appeared on that day, but petitioner nobody appeared. So who said 17th May? He directed only Monday. What is
Yes,
the
Mr. Mukherjee, when did we direct this matter to appear? Today itself. Yeah, state recording was it? No mistake.
None appears for the appellant. Even on the last occasion, that is on 12th April 2023, none appeared for the appellant. Mr. Om Narayan Rai and Mr. Debanjan Mukherjee, advocates, appear for the CESC Limited. Appeal dismissed for non-prosecution. Next.
Item number 3.
Grateful.
I beg to appear on behalf of the university.
I am for the petition, Your Lordship. Your Lordship, the affidavit of service is prepared, Your Lordship. So please kept in record, Your Lordship.
My lord, it is, may I just refresh your lordship's memory, my lord, it is with regard to challenging the, my lord, decision of the Bardwan University in taking the entrance of the law examination on the basis of the mark is a 3 years course on the basis of the marks obtained in the graduation plus level. My lord, the petitioners, my lord, challenges that, saying that why shouldn't you take it as a written test, written entrance test?
Exactly.
Your Lordship, the grievance of the petitioner is that, Your Lordship, the Bardwan University, Your Lordship, conducting the admission process, Your Lordship, without taking the entrance examinations. But the course of LLB 3 years, Your Lordship. Your Lordship, the admission process, Your Lordship, undertaken by the Bardwan University, Your Lordship, in what basis they are conducting? On the basis of the marks obtained in the secondary, higher secondary and graduation, Your Lordship. So, Your Lordship, this is the actual things which are making classification, Your Lordship. Your Lordship.
Prior to COVID, they used to conduct examination.
Indeed, Lordship.
Up to which year they had conducted examination?
Last 2017, Your Lordship, they last conducted the entrance examination, Lordship. And during the COVID period, Lordship, some
2017 they conducted. What about 18, 19, 20?
But from 20 onward, excellent. Marad, I have my third lordship, some query may come. I've got the even a competent officer with me. But I've been told that this system has been started from 2020 session onwards.
2021.
1920. I'm sorry. 2019 from the issuance of the COVID. 2021.
Then why can't you restore back to the original position?
No, I'm sorry. It's from 2021. He is giving me the instructions. But if he concludes, I'll start.
But that he's got nothing more.
He's got nothing more to say.
This is the matter.
Well, let me first, start with this. My first submission is that, there is nothing adversarial against this. The university is concerned with the beneficiary of the students. Whatever falls from your lordship, will do that. But I might just try to point out what was the decision, basis of the decision, and what will be the problem faced by the university if we go back now to this stage. I'm going to tell your lordship, the process বলছি।
Coming to the class, most of the universities have got option. But prior to, that is prior to 2021, you had been conducting your own examination,
Lordship.
but you have not been admitting based on CLAT score.
Based on sorry,
CLAT. CLA.
CLAT
No,
is
Your
only for
Lordship.
the national universities.
No, it's not that.
Well, not for here.
Certain other universities.
Yes, I'm sorry, but not.
Private universities have also
Yes,
gone by
but
the
not in the Bardwan University.
All right. So now, prior to 2021, 1920 session, on what basis did you conduct this entrance examination?
I'm deeply obliged. My lord, the rules of the Bar Council of India specifies, my lord, does not specify anything about written examinations. I have come with the rules. What are the rules? If your lordship takes the book, my lord, this is, my lord, rules, my lord, this is the rules. Rules of legal education by the Bar Council of India. I'm handing over 2 books. But if your lordship takes rule 5, well, rule 5 specifies both for the 3 years course as well as 5 years course. This is the basis of the examination. Now, my lord, I put your lordship. Wait a minute. Ordinance, sorry.
Rule 7.
And followed by rule 7. I'm deep level. And now a question came up before the Bar Council itself.
Proviso to rule 7.
My lord, now the Bar Council issued the clarification notification. My lord, handing it over to your lordship. My lord, kindly come straight away to the penultimate page. The others are all, my lord, the hyperlinks. Come to the penultimate page. At the bottom, lordship will find lordship's educational criteria and educational qualifications required for admission to 3-year and 5-year law courses. Lordships have got that. The penultimate page. The last but one.
Yes.
Yes, my lord, kindly see, this was the clarification by the Bar Council. The Legal Education Committee in its meeting held on such and such considered the matter relating Rule 5 of the Legal Education Rules, clarified the definition of basic qualification and eligibility of candidates to get admitted to 3 and 5 years law course. My lord, kindly turns over. I'll only place the relevant portion.
Third paragraph.
I'm on the third and the last. I'm deeply obliged, my lord. Kindly sees the third and then the last, which is very important. Rule clause 7. Minimum marks in qualifying examination. The Bar Council of India may from time to time stipulate the minimum percent of marks. Now, not below 45% of the total marks in case of general category applicants, 42% for OBC category, and 40% of the total marks in case of SC and ST applicants to be obtained for the qualifying examination, such as class 2 examination in case of integrated 5 years course, or we are concerned with this degree course in any discipline for 3 years LLB course for the purpose of applying for and getting admitted into a law degree. So, these are the cutoff percentage marks for applying and getting admitted. Then kindly see the proviso, provided that such a minimum qualifying mark shall not automatically entitle to get admission into an institution, but only shall entitle the person concerned to fulfill other institutional criteria notified by the institution concerned. So, those are the qualified cutoff marks followed by the institution criteria. Now, if your lordship, we were always following these cutoff marks. Now, if your lordship takes the impugned, my lord, information sheet, if I can call it impugned, at page 29 of the writ petition, this year's, which he has challenged.
Yes.
Starts at 29. Well, if your lordship kindly turns to page 30, 30. Kindly sees clause 5. Lordships have found it?
Yes.
I'm deeply obliged. Eligibility. Well, lordship will find the percentage of marks to be exactly same as that specified by the Bar Council of India. Now, my lord, the question comes, what are the other institutional criteria? My lord, kindly takes page 31, clause 8. This is the mode of selection for admission. My lord, we have stated categorically, my lord, technically, what will be the grade pay, I'm sorry, the grade points, the GP, how it was. This is the institutional criteria. So, if you have this basic qualification as per the Bar Council of India, this basic percentage of marks, you will be entitled for the, that is the threshold, then this is the basic point. So, my lord, number one, my lord, my submission is that
this is not in dispute.
This is not in dispute.
He doesn't dispute that.
No.
This position came into place from the academic session 2021.
Lordship.
He wants you to revert back
to
1920.
And I tell your lordship now. My lord, when we started this, Now, my lord, if your lordship just recollect.
Oh, what has happened to this is already.
I tell your lordship,
applications
I'm
are
coming
being-
to that. My lord, this was issued on 16th of March
Yes.
and valid till 31st of March. When
That
by
is-
31st of March, my lord, there is a total number of 2,234 number of applicants who have already submitted with the prescribed fees. Number one. Number two, my lord, I am just submitting this. Well, there must have been a mistake. Out of these 200 and 2,234 students, well, not only merit, but the petitioner is listed there. He has also applied. I have got the website live still going on at serial number 1930. I've got my officer. Lordships can very well say that we can proceed with the PIL, but he has applied. That is number two. But
Probably-
besides that, now I tell you what the problem that the university is facing. Well, we can commit to your lordship that from the next session we shall go back to this. Now the position is, well, the session starts from January, February. Well, because of this some delays and everything, it is now being done. But if I go back today to the written examination and correction and 2,234, well, I can only assume that some more may be added. But it will take us at least 2.5 to 3 months for the paper correction and entire process to get over.
24, 25, you can revert.
But I have got that in writing from the Vice Chancellor.
24, 25.
Yes. Now, my lord, that is number one difficulty. So what the difficulty will be, this session can only start from July onwards. I am bound to do it from January. The next session I have to do it from January, February. So there will be 2 sessions running parallelly for the same course. Now, and my lord, I tell your lordship, this similar identical question, or almost identical, came up before this honorable bench with regard to Calcutta, University of Calcutta. My lord, an order was passed on August 22, 2022 by this on the esteemed bench. But almost on the similar grounds, your lordship have a look at this. The same thing was said, the same difficulties, and it was, my lord, directed over here. It was same thing that you go back from it from the next session onwards. But I'll place that. But lordship may not trouble and your lordship with the entire order. Well, kindly see the second paragraph. The submission of the learned counsel of the petitioner is recorded. Lordship will find more or less the same contentions. Now, kindly takes, my lord, internal page 4. Another writ petition was filed earlier that has been quoted. Now, my lord, kindly takes this paragraph start at the last paragraph of page 5.
On what date you are going to publish the merit list?
Well, because we are holding it because this PIL has been filed.
But your petitioner has applied.
Indeed, your lordship, but
For the
what
next
I am
academic session, it can be done.
indeed, your lordship, what I am concerning about, your lordship, the word merit, your lordship. Merit, your lordship, in this, there's actually a case, your lordship, the apex court decided, your lordship.
My lord, I've been told we can publish the merit list by 7 to 10 days.
From
From
10
7 to 10 days.
But now we can't set the clock back.
Your lordship, this is the issue,
So
your
it-
lordship,
it's a
which
good-
are actually,
It's a good move. So from the next academic session, they will revert back to
Yes,
the
yes.
procedure which was followed from 1920 onwards.
Lordship.
This writ petition.
your lordship,
styled-
the
styled as
case
a public
referred, your
interest
lordship, that on that case, your lordship, the money
So
was
we will
refunded, your lordship.
dismiss your writ petition with cost. You have applied. Have you disclosed in your affidavit that you applied for the course?
No, your lordship, I beg your pardon for that, your lordship.
You withdraw or 1 lakh cost we will impose.
Well, may I make a submission? Well, if this is a student's litigation, well, kindly do not do so.
No, see,
Thank
there should be some responsibility. You want to pursue a law course. You should disclose. But, probably you thought you will not be selected.
That was
and-
the impression I have been given, but lordship kindly passes an order on merit. Kindly do not.
No, all right. By this writ petition styled as a public interest litigation, the writ petitioner who seeks to pursue a 3-year law course in the Burdwan University prays for issuance of a writ of mandamus to direct the respondent number 3 to conduct entrance examination for admission in the course. Elaborate submissions were made by the learned advocate appearing for the petitioner in support of their contention that conduct of an entrance examination is a transparent method of selection of candidates, and the university ought not to conclude the selection only by adopting the marks secured by the candidates in the 3-year degree course. It is submitted that up to the academic session 2019-20, the Burdwan University had been conducting an entrance examination for selection of candidates to the 3-year law course. But but on account of the COVID pandemic, for 2 academic sessions, that is from 2021 and 21-22, entrance exam was not conducted. And therefore, the petitioner seeks for a direction upon the respondent university to conduct an entrance examination for selection to the 3-year LLB honors course for the academic session 2023 and 20-2025. The learned advocate appearing for the university would point out that that by notification dated 16th March 2023, applications were called for admission to the 3-year LLB honors course for the academic session 2023-2025, and the last date for application was 31st March 2023, and as on the said date, more than 2,000 applications have been received, and the writ petitioner is also one of the applicant for the said course. Further, it is submitted that the impugned notification, further is submitted that the notification issued for the academic session 2023-2025 is strictly in accordance with the rules framed by the Bar Council of India, namely the Rules of Legal Education 2008. And in this regard, the learned advocate has drawn our attention to Rule 5 and Rule 7 of the said rules. Further, it is submitted that identical issue was raised before this court in WPA within bracket P 325 of 2022, etc. in respect of the notification issued by the Calcutta University of Calcutta, inviting applications for admission to the 5-year BA LLB course for the academic session 2022-23, and the division bench by order dated 22nd August 2022, after considering similar submissions as made by the petitioner before this court, had dismissed the writ petitions. After we have elaborately heard the learned advocates for the parties, we need to observe that under Rule 7 of the Rules of Legal Education 2008, there is a proviso which states that provided that such minimum qualifying marks shall not automatically entitle a person to get admission into an institution, but only shall entitle the person concerned to fulfill other institutional criteria notified by the institution concerned or by the government concerned from time to time to apply for admission. The respondent university should bear in mind the importance for inserting the proviso in Rule 7. Since the selection of candidates for the 3-year LLB honors course should be broad-based, the rule framing authorities thought fit to include the proviso. Therefore, the respondent university cannot make the proviso redundant by adopting the procedure under Rule 7 of the rules without reference to the proviso. If an entrance examination is conducted, the selection will not only be more broad-based, but it will also ensure that the candidates with the right aptitude are selected to the said professional course. In any event, we are unable to grant any relief to the writ petitioner for the current academic session for the following reasons. Firstly, that the notification was issued on 16th March 2023, and the last date for filing the applications is 31st of March 2023, which is already over. and more than 2,000 applicants have filed their applications. And the list has already been prepared by the respondent university. Therefore, at this juncture, the admission process cannot be interdicted. Full stop. The next reason being that the petitioner himself has applied for the said course, and this fact has not been disclosed in the writ petition. Therefore, we are not inclined to grant any relief to the writ petitioner for as sought for with regard to the admission to the 3-year LLB honors course of studies for the academic session 2023-2025. However, no, full stop. As admitted by the respondent university that prior to the academic session 2020-2021, the respondent university had been selecting candidates by taking into consideration the marks secured by the candidates in their graduation, as well as the marks secured by the candidates in the entrance examination, which was conducted by the university. The only reason given before us for suspending the conduct of the entrance examination is on account of COVID pandemic. Therefore, it is the respondent university should definitely revert back to the original procedure and conduct the entrance examination for admission to the 3-year LLB honors course, as well as for the 5-year LLB course from the academic session 2024-2026.
If you allow me to one interruption.
2026. The learned advocate appearing for the respondent university on instruction would submit that the respondent university will revert back to the old procedure and will conduct the entrance examination before finalizing the admissions to the 3-year LLB course and the 5-year LLB course for the academic session commencing 2024. Full stop. This undertaking given by the respondent university is placed on record. Yes.
One interruption, Your Lordship. This is the issue is that, Your Lordship, is not only about the Bardhaman University, Lordship. In this Kolkata University, Lordship, the same thing is happening, Lordship. This is the true fact, Your Lordship. The government colleges, Your Lordship, are less than the private law colleges.
For the writ petitioner, after having heard us dictate the above judgment, above order, would submit that the issue does not relate to the University of Bardhaman, but other universities as well. The writ petitioner has sought for a direction against the University of Bardhaman, and that is how the writ petition had been drafted and filed. More importantly, the writ petitioner has suppressed the fact that he had applied for selection pursuant to the notification dated 16th March 2023. Therefore, we could have outrightly dismissed the writ petition at the very threshold. However, we did not do so, considering the important issue flagged by the writ petitioner with regard to how the selection should be made by the University of Bardhaman. Therefore, at this juncture, we cannot permit the writ petitioner to expand the scope of the present writ petition. With the above observation, the writ petition
May I
stands
just make
disposed.
two clarifications, Your Lordships, allow me. It has fallen from Your Lordship that both 3 years and 5 years. The University of Bardhaman only conducts 3 years law courses.
5 years.
And the second is, it has also fallen prior to when we used to take the written examinations, the graduation marks as well as the written examination. It was only the written examination marks were considered. The graduation marks were
eligibility only.
Were only for getting them the qualifying eligibility. Only the written examination marks were.
I said, taking into consideration the marks obtained in the graduation for the purpose of deciding the eligibility of the candidate to apply for the 3-year LLB honors course.
But I have been told that we have continued with this process not only because of COVID, but the university also is found it to be more transparent. But I'm deeply obliged.
Under the Bardhaman University, there are 2 other universities as well, Your Lordship, who are conducting the 5 years LLB, Your Lordship.
You go to your chambers and think. Thank you. Next.
I'm deeply obliged.
Item number 4. Lordship, I beg to appear on behalf of the petitioner.
You said there are some two connected matters.
Yes, Lordship, not two connected matters, only one writ petition. One appeal application has been filed. Actually, Lordship, in this case, there is a scam of service regarding Uttarpada municipality. Without taking any help of Municipal Service Commission, all recruitment has been done.
Now, this PIL is of the year 2018.
Lordship?
This writ petition
Yes.
was filed in the year 2018.
Yes.
What happened?
But, Lordship, since then, this matter never came up before your Lordship. And it has been, is a transferred brief to me.
But I am appearing on behalf of the Uttar Pradesh Kutumang Minister, along my senior minister Deepak Kumar Mukherjee. But I have in my mind the three questions, my lord. Prior to that is the maintainability regarding whether this in the service matter.
I have not yet finished yet. I have not yet started.
No,
But,
my lord.
we can't.
I am raised the maintainability point, my lord.
You don't want to address the court.
Lordship, I am sorry.
You are not there to address each other. No, you address the court. We have not said anything on its submission.
Lordship,
Please address it.
Lordship, my case is
2018. You filed the writ petition. No steps was taken by the writ petitioner union to list the matter because there is not an order sheet. It is
there is not a single order sheet. I know, Lordship.
It's a change brief doesn't make difference.
Lordship,
you should not have accepted this change brief unless and until you knew what had happened here.
Lordship, that's why a supplementary affidavit has been prepared by me.
So furthermore, second point, you want to cancel the selection of all selected candidates. Selected candidates are not being implemented as respondents.
Yes.
Thirdly, this is a PIL in a service matter. Already candidates have been selected. Unless and until the selected candidates, if you want to withdraw and file a fresh writ petition with all particulars. At this juncture, we can't do anything.
Then Lordship may grant liberty to.
No, we will say that these are all reasons on account of which we can't entertain the writ petition, because if suppose the employees union has filed, an aggrieved person has not come before court. Prior to 2018, selection is over.
I can understand, Lordship.
Probably 15, 20 people might have selected, 30 people might have been selected. Those people are to be heard in the matter. They've been working from 2018.
Absolutely, Lordship.
So do something.
In that case, I may be directed to add them as a party to the case.
So there we see.
Because most of the persons who has been adopted in this recruitment, those are relatives of the local councillors, of the wife of the vice. Suppose the vice chairman of one municipality has been adopted in
No, my lord,
something like this. Have the list of the recruitment.
We have
from very date, and even those who have already could not pass, even their record is everything, all record.
And my lord, the Supreme Court has already decided. My lord, kindly look into this judgment, my lord, passed on in the 16th March 2023, my lord. The trade union or union, paragraph 21 and 23, my lord. 21 and 23. Address টা করে
অ্যাড্রেসটা করে আপনি দেখান আমাকে লিখে নিতে এটা
My lord, in the last portion, the honorable division bench of the honorable apex court, my lord, clarified that in future all the cases to be filed and all the pending cases, this is the pending cases, the parties shall be required to furnish their permanent addresses. Even if the representative of the workman is appearing, he shall furnish permanent address of the workman as well. Even in proceeding subsequent to the first stage, it shall be mandatory to provide the permanent address of party service. Merely mentioning through a labor union or authorized representative who are sometimes the union leader or legal representative will not be sufficient, my lord. But it is not prospective, it is respective also. My lord, first portion of the order, in future, all the cases to be filed and all the pending cases. That means it is not prospective, it is not respective also, it is a prospective also.
Please come.
Service notice.
Lordship, in that case, I may be given liberty to file afresh on the subsequent cause of action.
Liberty at this juncture, when the parties are not there, that liberty will impinge upon their rights. So what we'll dispose it off, then you advise your clients what to do.
And Lordship, one more thing, one case is there which has been filed by one of the learned member of the bar.
That let it come separately. Don't tag it along with this.
As well, Lordship.
This
Madam.
writ petition
Lordship,
was
then
filed in the
that
year two-
mention slip I was preparing to submit for
No,
enrichment.
not today, not today. Next week we'll see that matter. This writ petition was filed in the year 2018 as a public interest litigation by an employees union seeking for a direction to cancel the appointment of all the selected candidates pursuant to the recruitment process initiated by the respondent municipality. In furtherance to the memo dated 5th August 2011 and 16th November 2012 and another memo dated 14th July 2017, which had published the list of selected candidates. The writ petition is not maintainable for more than one reason. Firstly, the selected candidates have not been implemented as respondents. Secondly, the writ petitioner is an employees union and they have not disclosed the full particulars of their union and as to how they are exposing the cause of how they are exposing the said cause. The learned advocate appearing for the respondent submitted that all records are available to show that the entire recruitment process was fair and reasonable and all the selected candidates are working since 2017. Reliance has also been placed on the recent decision of the Honorable Supreme Court in Creative Garments Limited versus Kashiram Verma, Civil Appeal number 5758 of 2012, dated 16/3/2023, wherein the Honorable Supreme Court has issued certain directions in respect of pending cases as well as in few cases which have to be filed in future. In this regard, the learned advocate has drawn our attention to paragraph 23 of the judgment, which is quoted here and below. As pointed out earlier, the selected candidates having not been implemented as a party to the writ petition, the prayer sought for cannot be granted. Hence, we are not inclined to entertain this writ petition and the writ petition stands dismissed.
Grateful, man.
The learned advocate appearing for the writ petitioner submitted that liberty may be granted to the petitioner to file a fresh writ petition. Since we have pointed out that the writ petition itself is not maintainable at the instance of the petitioner union, we cannot grant any such liberty, but we can observe that it will always open to the appropriate person to invoke the appropriate remedy in accordance with the law.
Grateful, Lordship.
Yes.
Grateful, my lord.
Next.
Item number 5.
My lord, I am for the petitioner. My lord, this is my affidavit of service.
I'm appearing on behalf of the Union of India, my lord. My lord.
Construction of a underpass in National Highway. Made a representation. I am praying for consideration of the said representation.
My lordship.
The people have come before your lord.
But Supreme Court says you don't interfere in all these things.
No, my lord. Any
Because National Highways Authority of India is a specialized body. There is a decision of the Supreme Court which clearly says that if an individual landowner is affected, his lands have been acquired without following the procedure. He comes to court challenging the acquisition. It's a different matter. It is not for a public interest litigant to say, please put the underpass here, please put the cattle pass here, please put your flyover there, please have an access road to the left, access to the right. High Court don't interfere. That's the and they will say that we have got a particular norms. This is a 4-lane or a 6-lane?
a 6 lane. Already 4 lane, my lord, from 1990, but now 6 lane and already paragraph 5, 6.
So let them
Kind
as
of
an
looking-
expert body. You are for the national.
Lordship, I am appearing for the National
a
Highways Authority, Lordship. The Lordship, I have not access to your Lordship. Lordship, in the morning, Lordship, I received the brief. If your Lordship kindly,
No, if at all it is feasible, you consider.
Yes.
Lordship, can you give a one-day
He
accommodation,
will
Lordship?
indicate that it is not for us to tell you where to put the underpass, where to put the
Lordship,
bypass,
Lordship.
where to put the flyover. But you find that there is a genuine request, you can always, you pursue your representation.
Already.
You pursue it with them.
Lordship,
By this writ petition filed as a public interest litigation, the petitioner seeks for a direction upon the National Highways Authority to construct an underpass near DAG number CH 573 in NH2 at village and post office Jyotiram.
Jotram.
Jyotiram.
Chandaipur.
Bamchantaipur, district Purva Bardhaman. As pointed out by the Honorable Supreme Court, it is not for this court to decide as to where an underpass has to be constructed or other facilities have to be provided in respect of a national highway, as it has been held that the National Highways Authority of India is an expert body and all these matters are better left to the decision of the expert body. Therefore, the relief sought for in the writ petition cannot be granted and the writ petition is dismissed. However, this will not preclude the writ petitioner from pursuing his representation before the appropriate authorities. Next. Call.
Item number 6.
And for the respondents.
Then come and yes.
My lord, it was that matter where your lordship's desire was to sit with the government, my lord.
Yes.
My lord, I'll tell your lordships what happened. My lord, they gave me the list on Monday. Then they asked for a date after the 13th. The notice will go out today. And that day, your lordship didn't pass the order, my lord, because it was penned down. My lord, kindly, my lord, direct the chief secretary and finance secretary to consider, my lord, their representation relating to this budget, my lord, which was.
No, not represent.
Sit, yes, my lord, to consider, my lord.
In a meeting, my lord.
In a meeting, to hold a meeting with regard to, my lord.
So once again, see, we read in the newspapers that the matter before the Honorable Supreme Court has been adjourned.
Yes.
At whose instance it was adjourned?
My lord, subject to correction.
May I say one thing?
You are not a party in the Supreme
Oh, Lordship.
My lord, with deepest of respect, the matter was taken up, but the business of the honorable court, my lord, did not permit because the honorable court, one of the judges of the honorable court was going to remit his office, my lord, in the month of May. My lord, that is why it has been.
What is the next date?
24th of this month, my lord.
24th of April.
My lord, there were some hearing matters which were happening, my lord. So, my lord.
But in the meantime, once again, you shouldn't issue a notification of pen down or go slow.
Nothing has been issued till date, my lord.
My lord, may I indicate?
Can we take that as an assurance? Where is Mr. Bikasan Bhattacharjee?
My lord, as he mentioned before your lordship, for some personal reasons, my lord.
He is not here.
He is not here. He will be available on Thursday, my lord. If
your union office bearers are here?
Yes, my lord. One of the office bearers of the
Please ask him to step forward. We'll just sit down.
Yes, my lord.
Yes, sir. So what we were observing, whether you were there the other day?
Yes, I was there.
You were present in the courtroom?
No. We are not.
We didn't have anybody.
We are not.
No assistance at all. Thanks to your call. But the only thing what we observed was
was a specific case, my lord, that no dearness allowance is payable. But my lord, their agitation now also includes, my lord, that 3%, which is, my lord, now another further 3%, 6%, saying this is not what should be granted as by way of dearness allowance. They're pressing for a higher, my lord, rate. There your lordship said, my lord, there your lordships indicated if we could have, my lord, a negotiation on that. Because in Supreme Court, what's in the Supreme Court, my lord, it's there, my lord.
That's why we pointed out last occasion, there are two issues. One is ideas.
Correct.
Second is percentage.
Yes.
And they were saying that this is the only state in the country where the dearness allowance is a single digit dearness.
Correct. So
that is what they are agitating. So probably when you sit for a dialogue, you can have a clear demarcation. The arrears, etc. issue is there. Whether any revision of the percentage.
Yes, my lord, that's my lord, where, my lord, I thought, my lord, there could be, my lord, negotiations. And my lord, if they,
because the neighboring states are all on double digit.
my lord, that's one side of the picture.
It is up to the government.
No, my lord, my lord, not just that. My lord, there are several other things other than dearness allowance. My lord, we have to look at, my lord, the financial package, my lord, at the end of the day. So, my lord, I believe, my lord, negotiations will help in, my lord, understanding each other better. But, my lord, this is only with regard to rate. With regard to, my lord, arrears, my lord, what has happened is before the Supreme Court now, my lord. So, my lord.
So, you have an open dialogue. For the present, we have requested them not to precipitate the issue. We will make some observations in this order, and this will come.
Let's come to page 37.
You have pointed out an issue, leave it to the court, we will pass an order. If you are not satisfied with this order, you take it through.
The order was issued by Finance Secretary Manoj Pant on Saturday. A bureaucrat said on.
We know about it, sir. We know about it. Before even you file the writ petition, part of your affidavit is published in the newspaper. So when morning, everybody will read the newspaper. What is?
I want to say only one thing, Lordship. I am asking myself, what is the relation between DA or siege war, pen down,
No,
or any other age?
That's a form of protest they are showing. They say it's a peaceful protest. I am entitled to do that. You cannot prevent me. You have rightly highlighted that what is the prejudice caused to the entire society on account of this one day ceasefire. Well taken. Well taken. There's no issues.
Only one thing, my lord. With regard to ROPA 2019, there is no litigation pending, my lord. We are also not getting the benefits in terms of ROPA 2019. That is also one of the.
That you sit for a dialogue.
Yes.
By this writ petition.
They are saying all time.
Petitioner, a practicing advocate of this court, has sought for issuance of a writ of mandamus to direct the fourth respondent to prevent the implementation of a bandh called on 10th March 2023 and 6th April 2023. The petitioner appearing, the learned, sorry.
Lordship, 15th March.
Pardon? Your prayer is
15th March.
15th March 2023 and 6th April. 6th April. Your prayer says 10th March. The petitioner appearing in person would submit that on account of the strike call given by the fourth respondent Federation of Employees, the innocent public are put to great prejudice, and it would cause and has caused great economic loss to the state, which cannot be compensated. It appears that the fourth respondent Federation has given the call for conducting a cease work on the aforementioned dates, highlighting the main issue with regard to the dearness allowance. On the last date, that is on the last hearing date, namely on 6th April 2023, when the matter was heard, we suggested to the Learned Advocate General that the state government can consider inviting the office bearers of the Fourth Respondent Federation for a dialogue. However, on account of no staff members reporting for duty on the said date, we were unable to pen down an order on 6th of April 2023. However, the Learned Advocate General was fair enough to state that no written orders are necessary and he will do the needful in the matter. When the case is taken up case was taken up today, the Learned Advocate General had submitted that the state will hold a dialogue with 3 nominees of.
No, my lord, it's become, they have, my lord, increased it after speaking to me. They've made it 5. My lord, they've given me the name, so it will be 5.
5 nominees of the Fourth Respondent Federation. And on behalf of the state, a committee headed by the Chief Secretary of West Bengal will be constituted and the date will be fixed for conducting the dialogue. The office bearers, Mr. Bhaskar Ghosh,
Yes.
Mr. Bhaskar Ghosh, not office bearer. Mr. Bhaskar Ghosh, convener of the Fourth Respondent Federation, is present in court. This court made certain observations as to how the seize work, which was conducted on 15th March 2023 and 6th April 2023.
My lord, it should be 10th of March. My learned friend's incorrect. The prayer is correct.
Prayer
It's
is
10th of March.
We also, sir, it is only 10th of March, not 15th. 10th of March 2023 and 6th of April 2023 had affected the functioning of this court, not to say about the other officers of the state government. The learned advocate appearing for the writ petitioner submitted that the government has issued an order that the employees who do not report for work will lose their salary and their absence will be treated as break in service. We are not here to make any observation in this regard, and it is for the state government to act in accordance with law. We have reasoned out to Mr. Bhaskar Ghosh, the convener of the Fourth Respondent, that the issue relating to the dearness allowance is now pending before the Honorable Supreme Court in an appeal filed by the state of West Bengal against the judgment of the Honorable Division Bench of this court. And it may not augur well for the Federation or its affiliates to give a call for a pen down strike or cease work, especially when the matter is sub judice before the Honorable Supreme Court. We hope and trust that this observation made by us will be taken in the right spirit by the Fourth Respondent Federation. Without prejudice to the rights of parties, the representatives of the Fourth Respondent Federation are directed to participate in the dialogue with the state government with a committee constituted by the state government headed by the Chief Secretary of the state. And this dialogue and whatever discussion is being made during those proceedings will not in any manner impinge upon the rights of the employees or that of the state government which has filed the appeal before the Honorable Supreme Court. The state government shall fix a date for the meeting within 10 days from date and intimate the intimate the convener of the Fourth Respondent so that 5 of its nominees can participate in the meeting on the date, time and place fixed by the Chief Secretary of the Government of West Bengal.
My lord, only one thing. My lord, the request, my lord said, my lord, the chief secretary as well as finance secretary should be there.
We,
Your lordship,
we said, say chief.
very well, my lord.
My lord, most humbly, may I submit on your lordship knows, my lord, in the West Bengal service rules, my lord, right to strike, we have a right to strike by your
We have,
lordship's observation.
even before you told, we have told the advocate general.
No, my lord, only one thing, with deepest of respect, my lord, most humbly, my lord.
We have not said your style, you.
No, your lordship has said, my lord.
We have only said this observation may appeal to you, that's it.
Your lordship's observation is a direction upon us, manner. We are bound by it. There is no question about it. Only one thing. These will also.
Direction is different from observation.
Your lordship knows already hundreds of show cause notices has been issued for break-in service, and some of them have been implemented. If this observation, my lord, will also be, they will take this in those proceedings, and it will also hamper.
So with regard to the notice,
yes,
which you said, we said we are not making any observation in that regard.
And my lord, only one line subject to your lordship's convenience, my lord. Those proceedings will not be affected.
The learned advocate appearing for the fourth respondent federation submitted that the observation made by this court should not be taken to be a direction on the state government. Full stop. We are clear in our mind that we have not issued any direction, and we had only recorded the submission made by the petitioner, pointing out an order passed by the state government, and the observation made by us to the fourth respondent federation was to the effect that we hope and trust that the observation would appeal to the fourth respondent. This clarification is issued in the light of the submissions made by the learned advocate for the fourth respondent that right to conduct a peaceful strike is a fundamental right in terms of the relevant rules framed in this statement. Yes.
Lordship, may I say one thing?
This post of.
One of my learned friends said, continuous siege work and continuous.
No, that he will next. Please call.
Could not be tolerate.
Next. Item number 7.
Item number 7.
But I have instruction to appear on behalf of the private respondent, but not no copy of the writ petition is being served.
Private respondents from putting up the two-storied building in public canal.
My lord, we have served, my lord.
Why you are permitting, sir? Why you are permitting to put
We are
it?
not permitting, my lord. DM has directed the block development officer to inquire into the matter.
Page 72 of my
Inquiry has
lordship's brief.
Inquiry has
instruction is that this property was owned by us.
You
Thereafter,
don't know.
the acquisition was take place.
By
And
this writ petition.
the possession was not.
Please hear the order.
Fine.
By this writ petition filed as a public interest litigation, the petitioner would state that the private respondents are putting up a two-storied building in a public canal. In this regard, representation has been given and action has been initiated by the district magistrate Purva Medinipur. And a direction has been issued to the block development officer, Kejuriji number 2 development block on 17th October 2022 to inquire into the matter. It is not clear as to why the block development officer, Kujiri 2 development block, has not taken further action.
But further action is required to be taken under 62 Act. That is called, my lord.
Unauthorized.
October 2022 district magistrate issued direction.
My lord, he has
That if
inquired.
that fellow has not taken action, he is
No, he has,
colluding with him.
he has inquired into the matter. I have got the report.
What does it say?
It says, yes, there is encroachment.
Take action.
Yes,
The
that
learned-
action is required to be taken under 62 Act.
Whatever is the relevant enactment.
My lord,
The
it
learned
is a
government
complete-
council appearing
it
for
is
the
a complete
respondent, official
procedure,
respondents,
so cause
submitted that inquiry has already been conducted by the block development officer and was prima facie found that there is illegal construction. If that be so, action should be initiated. The learned government council submitted that Action has to be initiated under the 1966 Act.
No, 62 Act. This is called, my lord, West Bengal public land. Bracket start eviction of unauthorized occupants.
Sir,
bracket-
sir.
West Bengal public land within bracket eviction of unauthorized occupants bracket closed act
1962. My lord, show cause, then my lord, hearing, then appeal, everything is there.
Then 2-story to become 3-story, 3-story to become 4-story.
I am not saying anything, but I am to assist the court.
Well, hence, I have prayed for an interim order, my lord, till such time the entire.
No further construction.
No further. construction.
We are not making any request.
The learned government council further submitted that action will be initiated under the said enactment. If action is to be initiated under the said enactment, then it goes without saying that the procedure under the enactment has to be followed, which is bound to take time. Therefore, the private respondent shall not put up any further construction in the property in question. The learned advocate appearing for the private respondent submitted that no construction is being put up by his clients. In any event, the authorities should ensure that no further construction is put up and action be initiated under the 1962 Act initiated within a period of 2 weeks from the date of receipt of the server copy of this order, and the proceedings be concluded within the time frame fixed under the said enactment.
Copy of the petition may be served to our.
We have served, my lord. My learned friend is seeking for a copy. I shall have. Definitely. Definitely.
Next.
My lord, may I have a copy of the report that has been relied upon by my learned.
We have not taken it from him.
Leave it. What takes, my lord, I can give.
No, we have not taken it. Let it be. If you want to go outside in the bar room, you can read.
My lord, I shall definitely order a cup of coffee.
Next. Yes.
Item number 8.
My lord, my affidavit of service in that matter.
Affidavit of service kept on record. Item 8.
But I appear for the state respondents.
But I am for the private respondents.
Illegal construction. What is this?
To appear for the petitioner. My lord, complaint, my lord, my page number 23. Against this.
Converting, altering the landed property before so and so, along with all others, to immediate steps in violation.
My lord, they change the nature, character, and mode of use.
What was the original classification?
Classification of land value is, my lord, in Bengali Bhagar, my lord.
Bhagar. Not agriculture, Bhagar.
What is the use?
Possibly Bhagar is used for those
grazing land.
Dead animals, my lord, are buried. Or dead animals are buried.
So what is he now constructing? House.
My respectful submission before your lordship is that on 23rd March 2023, one order was passed by the state of West Bengal. There are some aims and objectives where it has been decided on the part of the state government that such areas will be recorded as Jaher Than, that is a spiritual place or communal spiritual space. And it is a checkered history. Since long, this particular place was used for the purpose of communal spiritual purpose. Subsequently, our predecessors also used that land. Subsequently, we are using that land. Subsequently, government of West Bengal has passed this order. May I be permitted, my lord, kindly hand over this. After passing this order, after taking such decision, we have made representation before the concerned PLLRO to consider our prayer. And what is our prayer? We require that particular land is required to be recorded under the heading Jaher Than, as it has been notified in government notification. Jaher Than. And this is my representation before the concerned PLRO.
So your representation as well as his representation will be inquired into.
My lord.
You will be heard, he will be.
My lord, an opportunity of
only that, but
both parties.
Both parties.
Not all 100, one representative or two representatives.
My lord.
And only it will be considered by the additional district and district land
reforms officer.
Jiban Paul's Garden, Chinchura, Hooghly.
And it is not also clear how the related with the
How are
Jaher
you
Khan to
agree?
the private
Suppose
respondent.
if it
My
is
lord, that is-
converted as
No, we are not
Jaher Khan, if it is-
Jaher Khan.
so it will be for a
My lord,
communal
my
purpose.
lord,
sir.
Communal spiritual purpose, my lord. We are not using for our private enjoyment.
By this writ petition, the petitioner seeks for a direction upon the respondents not to convert the character and use of a land in the area in question. In this regard, a representation has been given on 7th March 2023 to the second respondent. And since immediate action has not been taken on the said representation, the petitioner has approached this court. The learned advocate appearing for the private respondent submitted that the local people whom he represents have filed a representation before the second respondent by placing reliance on the government order in memo number 192-TDD, all capitals, /5 capital C -01 capital /2023 dated 23rd March 2023. And the said representation is pending before the second respondent. Since the petitioners have come before this court stating that their representation has not been considered, and the private respondents have placed reliance on the order passed by the government dated 23rd March 2023, we are of the view that the second respondent should inquire into the matter after issuing notice to the representatives of the petitioners as well as the private respondents, and then take an informed decision in the matter and pass a reasoned order. In the light of the above, the writ petition stands disposed of by directing the second respondent to consider the representation given by the petitioners dated 7th March 2023, as well as the application, as well as the representation given by the private respondents to the second respondent, and the representative of both parties be heard in person, and an informed and reasoned decision be taken on merits and in accordance with law.
Item number 9.
The above direction be complied with within a period of 3 weeks from the date of receipt of the server copy.
Affidavit of service kept in.
Affidavit of service kept on record. Disposed of. Next.
Item number 9.
But I appear for the appellant petitioner.
Yes, sir.
But this is a public interest litigation, my lord. The purpose is to, my lord, fill up or conduct a by-election in respect of a constituency in the assembly, constituency, my lord, at Maniktola. My lord, the returned candidate, my lord, was declared elected on 2nd of May 2021. Unfortunately, my lord, he was of course a minister also. My lord, he has expired on 20th of February 2022. Now, my lord, by-elections have not taken place. But what I need to draw your lordship's attention is.
But election commission has to know.
Yes,
My lord, I am representing my lord.
Yes. But I need to, my lord, bring one thing to your lordship's notice, my lord, which may be a legal issue, where there's a election petition pending, where challenging his election.
But what will happen to that election petition?
Yes, that is what, my lord, your lordships would require to, my lord, consider, because
That
there.
the commission will.
My lord, please come to page number 38, my lord. Page 38. The order starts from page 37, therefore 38, my lord. My lord, will I read it out, my lord?
Please.
My lord, it is directed that the disposal of the main petition, the documents, the election papers, and the devices connected with the instant case be preserved by the concerned authority who is supposed to be the custodian of such documents and other materials mentioned herein above during the post-poll phase. My lord, all is preserved before the district election official, my lord. And with regard to the same issue, my lord, there is one judgment with the Supreme Court that when the election is pending, my lord, page 35, my lord. When the election petition is pending, my lord, the Election Commission of India cannot declare, my lord. There is a provision under section 151A that can be declared, but when election petition is pending, my lord, page 35, para 35, my lord. Sorry,
So there is a bar.
yes, my lord, there is a bar, my lord.
My lord,
Until because the candidate who had lost, my lord, he has asked in the he appeared in the election petition is that he is to be declared as the selected candidate. Now, until and unless that period is there, my lord, nothing can be done, my lord.
May I make a
Para
small
30, my lord, para 35 is the paragraph, my lord. Para 35, my lord. What is specifically stated by now they are fully contesting, my lord. Explainer number 3 and 8 had filed the written statement.
So wherever election petitions are pending, it cannot be held that they have become available for the purpose of being filled up.
But only
Until and
one
unless that-
thing, subject to correction, my lord, possibly, my lord, this was a case where the candidate had resigned. And my lord, that was accepted by the speaker. And possibly, my lord, he was elected to Rajya Sabha or something of that sort.
Whatever resignation, death or anything.
Yes, my lord,
So the
same
issue is vacancy.
Yes.
vacancy.
So Supreme Court says, we are of the firm view that the introduction of section 151A in the Act did not alter the position as far as provisions of 84, consequently 98C, 101B of the 51 Act are concerned. Since although a casual vacancy may have occurred within the meaning of section 150, it can be by death or resignation. Those vacancies in which election petitions have been filed and were pending cannot be held to have become available for the purpose of being filled up within the time prescribed under 151A of the 1951 Act.
Yes. Now, please, my lord, have a look to, my lord, section 150 and 151A. Lord, I have a copy, my lord.
Representation of people, sir. Representation of people.
But I've got two copies, my lord.
Sir, please. Thank you.
Casual vacancies in the state legislative assembly when the seat of a member elected to the legislative assembly of a state becomes vacant or is declared vacant, or his election to the legislative assembly is declared void, the election commission shall, subject to the provisions of the subsection 2, by a notification in the official gazette, call upon the assembly constituency concerned to elect a person for the purpose of filling the vacancy so caused before such date as may be specified in the notification, and the provisions of this act and the rules and orders made thereunder shall apply as far as may be in relation to the election of a member to fill such vacancy. If the vacancy so caused be a vacancy in a seat reserved, kindly skip over that. Then please take 151A. Time limit. Notwithstanding anything contained in section 147, 149, 150, and 151, a by-election for filling any vacancy referred to in any of the said sections shall be held within a period of 6 months from the date of occurrence of the vacancy, provided that nothing contained in this section shall apply if the remainder of the term, etc. Well, that is not applicable. So, but this is a period which has been fixed. Now, if your lordship may kindly take, my lord, the article 190 of the Constitution.
Constitution of India. Constitution. Yes.
Now, my lord, article 190, please take 190, sub-article 3.
Yes.
If a member of the House of the Legislature of a state becomes subject to any disqualification mentioned in so and so of 191, resigns his seat by writing under his hand addressed to the speaker or the chairman as the case may be, and his resignation is accepted by the speaker or the chairman as the case may be, his seat shall thereupon become vacant. Now, this is in one situation where the seat becomes vacant and somebody resigns or suffers disqualification. Now, please take, my lord, I don't trouble your lordship with the proviso. Please take sub-article 4.
Yes.
If for a period of 60 days, a member of a house of the legislature of a state is without permission of the house absent from all meetings thereof, the house may declare his seat vacant, provided that in computing the said period of 60 days, no account shall be taken of any period during which the house is prorogued, etc. Now, Millard, these are the provisions, Millard, where Millard, constitutionally, Millard, we find, Millard, how a seat becomes vacant. Now, subject to correction by my learned friend, because they are the experts in the field.
Because the unreturned candidate
Yes.
has filed the election petition.
Yes.
And he wants him to be declared as elected.
Yes.
On account of whatever the reason.
Yes.
That the court is seized of the matter.
I'll add more point in favor of my learned friend's client. The additional point is, Millard, two other candidates who had, Millard, contested the election after the expiry of the returned candidate, they have also applied and they have been granted permission to file written statement. Or in other words, they can also be declared as
so
elected.
therefore the problem becomes more complicated.
Yes, that honorable court has declared.
May I just make?
But proceedings will not abate.
Yes, proceedings does not abate. That is, Millard, section Millard 83.
All the documents are preserved, my lord. All the documents preserved.
Yes, yes, documents would be preserved.
Now, what will happen if the next election is held, my lord? All the documents are preserved.
Now, Millard, what happens to the people of the constituency?
That's the problem.
Yes, because as your lordships know, Millard, that the person who represents the constituency, Millard, he has got certain powers. We have certain disbursal powers.
Until unless this election period is disposed of, my lord, nothing can be done, my lord.
Yes. Now, Millard, so as abatement is concerned, please have a look at section 116, 116. The second part, your lordship will find, Millard, the written statements that have been permitted to be filed. If before the conclusion of the trial of an election petition, the sole respondent dies or gives notice that he does not intend to oppose the petition, or any of the respondent dies or gives such notice, and there is no other respondent who is opposing the petition, the High Court shall cause notice of such event to be published in the official gazette, and thereupon any person who might have been a petitioner, this part, any person who might have been a petitioner may, within 14 days from such publication, apply to be substituted in place of such respondent to oppose the petition and shall be entitled to continue.
So that's how those two people
come.
Yes, my lord.
So therefore, Millard, this election petition will go on. It is not that the death of the sole respondent or only the elected candidate that the proceedings abate. If some other persons who may have a right, who may also be declared as elected or who could have been a petitioner, apart from the one who has filed the petition, Millard?
No, assuming the candidate was alive, still it will not have it will have a representative, but still he will proceed with the election petition. So situation doesn't alter. Only thing is,
but if the candidate was alive,
he will represent the
constituency. May I just make a small submission, Malad? I am one of those, Malad, who came in subsequently, Malad, one of those contesting. Malad, in the election petition, I don't know whether the election petition not before your lordship, Malad. Your lordship, the petition was made in a very strange manner. First, Malad, the challenge was to the returned candidate that he is guilty of corrupt practice. And therefore, the person who's the election petitioner is the correct candidate. Now, after his death, what my learned friends or the petitioner has said that in the alternative, under section 101, declare me as the returned candidate. Now, that was subject to the corrupt practice vis-a-vis the returned candidate. Now, we have entered, well, I'll be very candid, we have filed the petition only on the ground that you cannot have a simple, straight on goal without a contest. That is what
you cannot have a cakewalk.
You just can't have a cakewalk because the person has passed away. So,
the court will decide in the election petition.
No, Malad, 101, that is what I'm submitting, Malad. 101, read with Malad, your lordship will find that the election petition is required to be disposed of or endeavor to be disposed of within 6 months. And that is my, your lordship will see.
You don't try to get an direction in this petition.
No, I'm not saying that, Malad. What I'm saying is, Malad, I do not have anything of that because I am contesting there.
But the point is, one of the question arises whether the election petition should
But
be.
you are not a party here.
I'm a party here, man. I've been made a party, man. That is
Respondent?
10, my lord.
10.
Well, both the persons will have been implemented as respondents,
Nine.
5 and 10.
5 and 10.
Those who have been allowed to file written statement.
By this writ petition.
But only one thing, if I may make the submission, where the judgments which I found is not where, my lord, the persons resign. Now, please consider, my lord, whether the same analogy.
No, as per the provisions, it doesn't
My
get
lord, if your
abated.
lordship kindly come to section 151A, my lord, in the end portion, my lord, case law nature, it is typically mentioned, my lord, specifically mentioned, section 151A does not pertain to vacancy or seat in respect of which election petition is pending, where relief of being declared elected has been sought by election petitioner, Election Commission India versus that judgment I have produced before lordship. It is specifically stated, my lord, in the 151A, if election petition is pending, then nothing can be done, my lord. In 151A, my lord.
Case law. That is not 151.
No, these are, my lord, all, my lord, interpretations given by the Supreme Court.
Resignation.
Where is he reading? You are reading
151A, my lord, that it is there. It is there in
Notwithstanding
my
anything contained in 147, 149, 150, 51, by-election for filling up the vacancy shall be held within 6 months from the date of occurrence of vacancy.
Yes.
Then proviso is when the reminder period is less than.
There is one part in my this case law. Recent exam. It may not be there, my lord. It is there in my book, my lord.
What is that?
I think he's referring to a
Judgment, my lord. That is the judgment that I referred, my lord. That is referred here also.
It's not a part of 151A.
That is not a part of 151A, but that has been referred over there also.
151A, what is this?
I was
Those are
also-
different
I was
ones.
also looking
No,
for
no, that is not, because that is referred over there also, my
We'll
lord.
consider.
All
By
right,
this
yeah.
writ petition, the petitioner seeks for a direction upon the official respondents, more particularly the election commission, to declare the by-election in the Assembly Constituency 167 Manik Tala and fill up the casual vacancy in the Legislative Assembly of West Bengal. According to the petitioner, if casual vacancy has occurred in the said constituency on account of the demise of the elected candidate. Therefore, direction has been sought for on the aforementioned terms. Further, the petitioner, page number 11. Further, the petitioner would state that even for more than 1 year from the date of vacancy, that is 20th February 2022, no steps have been taken to the respond by the Election Commission for declaration of by-election to fill up the casual vacancy arising in the said Legislative Assembly constituency. Thus, the petitioner would place reliance on the section, section 151 capital A of the Representation of the People Act, 1951.
It's 151A.
151 capital A. Representation of People Act 1951, within bracket the 1951 Act, wherein a time period of 6 months has been fixed for conducting the by-election. Admittedly, the election of the returned candidate was challenged before this court in EP number 9 of 2021 by one Mr. Kalyan Chaube, and the matter is still pending. And the court by order dated 16th July 2021 directed that till the disposal of the main election petition, the documents, the election papers, and the devices connected with the instant case be preserved by the concerned authority, who is supposed to be the custodian of such documents and other materials mentioned during the post-poll phase, POLL phase. The question would be as to whether the time limit prescribed in the prescribed under section 151 capital A of the 1951 Act would operate in the facts and circumstances of this case. The section 116 deals with abatement or substitution on death of the respondent in an election petition. The said provision states that if before the conclusion of the trial of an election petition, the sole respondent dies or gives notice that he does not intend to oppose the petition, or any of the respondent dies or gives no such notice, and there is no other respondent who is opposing the petition, the High Court shall cause notice of such event to be published in the official gazette, and thereupon any person who might have been a petitioner may within 14 days of such publication apply to be substituted in the place of such respondent to oppose the petition, and shall be entitled to continue the proceedings upon such terms as the High Court may think fit. On account of the demise of the returned candidate, the procedure under section 116 had been followed, and notice had been issued, had been published in the official gazette, and pursuant to which the respondents 5 and 10 herein have been arrayed as parties to the election petition. Thus,
may I interrupt? Insofar as my publication of the notice by the High Court is concerned, I am not very sure. But my lord, by 22nd February 2023 order, my lord, written statements were allowed to be filed.
Further, the said 5th and 10th respondent have also been permitted to file written statement in the said election petition. Thus, the election petition does not get abated as the procedure under section 116 has been followed. In such circumstances, section 151 capital A of the 1951 Act would not come into play. This very legal issue was decided by the Honorable Supreme Court in the case of Election Commission of India versus Telangana Rashtriya Samiti and another
2011, volume 1, SCC 370, my lord.
2011,
volume 1, SCC 370, my lord, page.
And wherein it has been held as follows. Please quote para 35. Last page, 35. There are no page number. Last page and the previous mark. In the light of the above legal position, it cannot be stated that a casual vacancy has occurred within the meaning of section 150 of the 1951 Act for the purpose of section 151 capital A of the 1951 Act to come into play. Therefore, the direction sought for in the writ petition cannot be granted at this junction. With the above observations, the writ petition stands dismissed.
I'm grateful, my lord.
Next.
Item number 10. I am appearing for the state, your lordship, in this. I'm not too sure, my lord.
My lord, this is my application, my lord. It's an application, my lord, I would say, to activate the administration to resolve the impasse, which is continuing in, my lord, the Purva Bardhaman court for 3 weeks.
This is where that some public prosecutor was.
Yes.
But, my lord, I am for the state, my lord.
What he can do about it?
My lord, it's for them to do.
No. This is fighting between two lawyers. How is the state? Probably they can register FIR.
It's for the state, my lord, to resolve the disputes because, my lord, the public.
No, already the concerned zonal judges have held meetings with the district judge, with the members of the bar. To that extent, I know. What has happened thereafter, I don't know.
But I cannot stand in the way that yes, it is correct that obviously the court should function. But my lord, ultimately, my lord, I'm not opposing as an adversarial in this, but my lord, my hands are also tied.
What can the state do?
I'll tell you, lordship, my lord. Both, my lord, as far as I understand, my lord, both the public prosecutor and the additional public prosecutors are appointed by them, my lord. It's for them to, my lord, take steps, my lord, to resolve the disputes. My lord, the general public should not be made to suffer for this. For 3 weeks, my lord, openly, publicly.
What you do is, say, you withdraw both the officers and post somebody, you sort out the problem and then post them. What else to be done? Now, the dispute is between the public prosecutor and the additional public or assistant.
My lord, yes. So it's
Assistant, no, who's a political appointee, who's a...
The public prosecutor is a appointee under, also statutory appointee. So, and the additional are all mostly
through selection.
Yes, madam.
Service Commission conducts selection.
No, I think it's the judicial department who.
All right. They apply for the post and get selected, and they function as APPs. And your appointee is a 10-year appointment. How many years?
I am not that.
Because what I am familiar with the practices, these tenure appointees will be entitled to conduct sessions cases. But the APPs who are selected through the Service Commission are not entitled to conduct sessions cases. They're up to the court of probably CJM, they'll be appearing.
But, may I just say this? Then, my lord, kindly keep it tomorrow so I can take that.
No, what can we do about it? You take your fellows are fighting with each other. Or we will say, have you implemented them as respondents? We will say both of them shall not be allowed to function in the court, and the state government shall nominate 2 other persons as an interim measure, and the court proceeding shall function.
There are a number of APPs, my lord. It's not that one APP is, my lord, doing this.
Obviously, then these APPs will join him. Those people, another set of APPs will join the public prosecutor. There is a faction.
My lord, may I say this? Your lordship, my lord, just to get this over with, my lord gives me a direction that to take all necessary steps to see that it functions. And my lord keeps it next week. Let me see whether I can resolve it.
They can, my lord. They can, my lord. If the government wants, my lord, they can. They can only. They have to only say the PP and the APP that resume the normal work. That's it.
And the Bar Association has filed this case.
No, some, my lord, individual, my lord, who was suffering.
He's not a lawyer.
No.
Why not a single member of the bar has got the guts to file the writ petition? Is it
difficult? Must be. Lordship should appreciate this. Let them, my lord, kindly keep it next week.
Probably if the Bar Association impledes itself and takes a stand which is contrary to
Bar Association has said, my lord, the concern, my lord, Bar Association secretary is one of the APP. Bar Association has said we cannot do anything.
Bar Association is not a party.
No, I have not. I have not. My grievance is against the state, my lord. It's for them to take the necessary steps.
By this, please take down. By this public interest litigation, the petitioner who claims himself to be a law-abiding, peace-loving citizen of India, and a peace-loving citizen of India, and a frequent visitor of the district court of Purva Bardhaman, where Purva Bardhaman, for his pending matters, has filed this writ petition to resolve the impasse which is going on in the districts and sessions court of Purva Bardhaman. Essentially, the matter got precipitated on account of an alleged incident which took place between the public prosecutor and the additional public prosecutors. And it is stated that certain ugly scenes took place in the courtroom of the district and sessions judge. the court is aware that the zonal judges, the honorable zonal judge was apprised of the situation and certain steps were taken. However, the issue or the dispute is between the public prosecutors who are appointees of the state. And therefore, the state owes a responsibility to ensure that normalcy is restored and the courts start functioning in a smooth manner, and the litigant public are in no manner affected. At this juncture, we are not inclined to issue any positive direction, but would make but would direct the concerned respondent of who Home Secretary issues the appointment orders.
Judicial secretary.
Possible. Judicial Secretary is our man, sir. What he can do about it?
But I think the appointment is by the judicial secretary, the department. Home Secretary, my lord, Chief Secretary will do.
Please read that last line. Direct the learned government pleader to speak to the concerned authority and ensure that the dispute is resolved and the courts start functioning in a proper manner, in a smooth manner. An action taken report in this regard be submitted before this court on the next hearing date. List the matter higher on board on 24th April. Next.
Item number 11.
Lord, item 11,
Yes,
there
my
is
lord.
an application at the instance of the learned Registrar General under directions of the Honorable Safety and Security Committee, my lord, which is registered as CAN 20 of 2023. My lord will kindly take it up, my lord. CAN 20 of 2023. পাইনি খুঁজে পাইনি দিয়ে দিচ্ছি Your Lordship.
This one.
इनपुट करने के लिए बोल कॉपी की
Actually, so far as this CAN application is concerned, there is a security committee which is
Yes. Kindly take
headed by Honorable Justice Somanson.
Yes.
And what is the other main writ petition?
Main
My
writ
lord,
petition
I'm-
is concerning the welfare of Victoria Memorial Monument. Where there.
Why have you filed a CAN application? Because the parking you want.
Yes, my lord, we can accommodate 900 cars and more than 1200 cars are being parked every day. We have consulted the fire department. We have consulted the ambulance people. They have said it's in a precarious condition. In case of an emergency, it will not be possible for firefighters to come. It will not be possible for modern day ambulances having life care facilities to, my lord, help affected people. My lord, if my lord kindly takes up page 18 of my application, there everything will be evident. My lord, we have consulted, we have called the army people because this area is under the army. Page 18 kindly turns up, my lord. This is the committee's resolution. My lord, may I read it for your lordship, my lord?
Page
18. My lord, may I read it for your lordship?
Yes.
The Colonel Land, West Bengal area is present. He has informed the committee that the Ministry of Defence, Government of India is the appropriate authority to grant permission for using stretch from Strand Road to Kingsway Crossing up to the boundary of Mohanbagan ground in between footpath to High Drain adjacent to Gangasagar Pilgrims Complex for the purpose of parking on a permanent basis. He has also informed the committee that there is a public interest litigation, which is this petition, pending, in which one of the issues is with regard to the utilization of space for parking in and around the Maidan area. Mr. So-and-so, Assistant Secretary, Incorporated Law Society, has also informed the committee about the pendency of the said public interest litigation. The representatives from the police authority as well as West Bengal Fire and Essential Services have stated that there is an immediate requirement for reducing the number of cars in and around High Court building. The representative from West Bengal Fire and Essential Services in particular has stated that during an emergency, it would be difficult to bring the firefighting vehicles and ambulance. The members of the committee deliberated on the issue and resolved that in the fitness of things, an application should be filed in the pending public interest litigation, praying inter alia for utilization of the stretch mentioned above to be used for car parking only. The Colonel Land West Bengal area has suggested a place in and around Second Hooghly Bridge, 2.9 kilometers away, owned by HRBC, that may be utilized for car parking. The members of the three wings of the bar have suggested that the said place may be utilized for parking by the litigants and may not be suitable for the members of the bar because of the distance. The Registrar General is directed to take up the issue with the appropriate authority of HRBC for allotment of the said land owned by HRBC for car parking. On receiving the response from HRBC, the committee shall decide the mode and manner and the persons who may be entitled to use of such car parking space. My Lord, if kindly then turns to page 42. My Lord, I was mentioning about certain figures, 900 and 1200. Page 42 of my application. My Lord, at the bottom, the paragraph starts with the representative of the three wings. The representative of the three wings of the bar have raised concern over inadequate parking space. The police authorities have submitted report wherefrom it appears that presently 1235 cars are usually parked in and around High Court premises, whereas the area can accommodate 933 cars approximately. The proposed car parking at High Court premises suggested by the police authorities, thereafter, my Lord, it is less. The areas are indicated. By this application, my Lord, we are seeking impleadment in the present PIL, and we are also seeking impleadment of the Ministry of Defense, Government of India, and the Chief of Army Staff, and praying for a direction in the judicial side of this Honorable Court, my Lord, to grant this permission to us for our safety, because there are three buildings.
But then, of course, we'll consider subject to.
I'm the petition number 2 in the original amended petition, my Lord, public interest. My Lord,
What do you say for this?
my Lord, I will come back. Because my petition was or is related to the preservation and conservation of Victoria Memorial, which is second to Taj Mahal, my Lord. My Lord, on the basis of the NIRI's report published in the year 1992, my Lord. And on the basis of that, the High Court observed that there should not be car parking around Victoria Memorial. Around Victoria Memorial, there is a red mark zone. And my Lord, they had suggested that the shifting of the bus terminus from the Dharmantala area, and my Lord, synchronization of the traffic signal around Victoria Memorial so that there is no haltage of any vehicle. Suppose synchronization of signals, your lordships possibly know that what is the process. And my Lord, there are certain directions upon the Victoria Memorial Authority, like that the green belt, and my Lord, lifting up underground water. Calcutta is suffering very badly that arsenic problem, and 34 feet underground water level has gone down. So in the backdrop of that, without permission from the Central Groundwater Authority, no one can. So these are the directions, and on the last occasion, the Honorable Court had directed me that to order date is 23rd April, 29th March, my Lord. Yes. Kindly come to the page second, last paragraph, my Lord. He means me. He is directed to inform the state about the next date of hearing that I have done, and issue in respect to his last sentence, my Lord, penultimate sentence, is permitted
application stating the issues which are still surviving the matter.
Yes, I filed that.
What is CAN number?
This CAN number is 19, my Lord. 19.
CAN number 19 you give. CAN 19 of 2022.
My lord.
Let him take that can. So
Application solution.
other can applications don't survive.
Other it has gotten no relevance, my lord.
So only two applications, one is filed by the High Court administration and one filed by you.
Yes.
What are the other dozen number of can applications?
My lord, actually what happened, the transport operators, because the bone of contention, and the bone of contention relates to the shifting of the bus terminus. There are about 4,000 plus long distance and short distance buses. They are terminating at Dharmatala area. That it is near to the 1 kilometer aerial distance from Victoria.
Pollution.
It is the pollution not causing damage to this historical monument. This is the largest sports hub in the country, largest, and the largest lung of the city of Calcutta, my lord, Calcutta Maidan. So, my lord, it is to save the people. The matter they what.
So you will be opposing the prayer of the High Court?
No, I will not.
No, implement probably.
No, implement
but they want that Maidan area to be given for parking.
My lord, I am coming to that. It is up to your lordship's discretion, my lord. It is up to your lordship, because the Supreme Court, the state had moved SLP before the Supreme Court, and Supreme Court upheld the direction of the Calcutta High Court that there should be traffic signal synchronization.
We saw in their
yes, man.
Page 39 is the Supreme Court order.
And my lord, it is not that the shifting of bus terminus. And
so we'll see. There are as many as 20 can applications. 19 alone, can 19 you have sought for.
Yes.
First is shifting
of
the bus terminus. Second is tree plantation, create a green belt. Third is vehicular traffic flow smooth and free around the memorial.
Yes, ma'am.
Rainwater harvesting inside the compound. Complete ban on burning of fossil fuel within 3 kilometers. So these are the 5 issues.
Yes, ma'am. Yes.
And we will ask who are the appropriate respondents who have.
Lord, my learned friend is.
I'm the Union of India. But these respondents.
Represents not the Victoria Memorial Hall. But we need to have a copy of the application.
Yes. So therefore, we can close all other applications. Keep 2 applications pending.
Yes, ma'am.
Can 19, can 20 of 2023.
Yes, ma'am. Yes.
So far as can 20 of 2023, please listen. So far as can 20 of 23 filed by the High Court, do you want to respond to their prayer?
Yes, ma'am.
You file your affidavit.
Because I want to assist your lordship with further more details, which are even my lord.
No, if suppose their prayer is allowed.
Relating to their prayer.
No, if their prayer is allowed.
I don't think my learned friend is opposing implement of the High Court.
Implement is not opposing. He is opposing your prayer to convert that Maidan area into parking. He says nobody comes inside.
No, my lord.
Leave it as a lung space.
Yes, my lord. It is the lungs, and my lord, it will contradict to the Supreme Court's and High Court's earlier direction.
So therefore, we will implead the High Court in the proceedings.
Yes, ma'am.
So far as the prayer in can 20 of 23 regarding parking, etc., you file your affidavit.
I'll do that.
Lord, I have also sought for implement of the Ministry of Defense and the Chief of.
There, I think.
Your Lordship, I am appearing for the Ministry of Defense.
You are not a respondent.
Your Lordship, you had already been added as a respondent.
You are already there.
Already.
I am seeking a direction upon them to grant me the permission.
As of now, we will only implead you as a respondent in the writ petition.
Before my lord passes the order, if my lord kindly turns to the Supreme Court order, which is at page 40, I am covered by these areas. Page 40. This is below 2011-13 SCC, page 55. I am referring to paragraphs 5 and 6, which I have also extracted in my application. We have heard the learned counsel for the parties, and we find from the recommendations of the expert committee that a committee of experts has observed that parking activities add to pollution load around the Victoria Memorial Hall, and have accordingly recommended that the parking of vehicles on all sides of the Victoria Memorial Hall compound should be totally banned. The High Court appears to have considered these recommendations of the expert committee and directed in the impugned order dated 28/9/2007 that parking around the Victoria Memorial Hall on the red marked portions of the map would be prohibited. Paragraph 6. The High Court has also indicated in the impugned order dated 15/2/2008 that there were many other places in Kolkata, such as the Maidan, the Eden Gardens area, and the area around the grounds of Mohun Bagan, East Bengal and Mohammedan sporting clubs, as well as the area by the side of River Ganges, where there was no restriction of parking the vehicles. Those who want to walk and take their cars to the place of their walk thus have sufficient number of alternative places in Kolkata where they can go for their morning walks. Lord, we are only wanting the areas indicated in paragraph 6, but the army says there is a pending PIL and the permission will be granted by the Ministry of Defense. There is no room for resisting.
From where do you get that there is no restriction of parking?
Paragraph 6, my lord?
No, paragraph 6 is observation.
Yes.
Is there any order to that effect?
Yes, my lord, kindly turns to the High Court order.
In another case, well, not in this case, there is no order like this. I have not heard. That was only for the morning workers of the Victoria Memorial. And they moved to the Supreme Court also. Their petition was rejected.
My lord, kindly turns to page.
My lord, for High Court area, my lord, one thing can be, because I've been doing this traffic and all this for the last almost 40 years. My lord, there should be provision for like in the Hyde Park and
You file your affidavit in opposition.
so my lord,
Now, my lord, with regard to this matter is concerned, my lord, so far the meeting in which, my lord, this decision has been taken to file this application, it's regards to, my lord, the parking of cars of High Court advocates. Now, my lord, the issue lordship knows, my lord. So, my lord,
As secretary, you will have your views. But personally, I have got some views. So therefore, I thought I should not hear this matter. After having visited Alipur, if this parking is permitted, I can conceive what will happen.
But my lord, but my lord,
there may be underground,
Permanent construction will come up.
underground parking can be
Only place where people can breathe.
no, my lord, only things is that
Don't propose to hear this.
no.
Today, what we will do is, we will close all his applications, keep CAN 19 pending. In CAN 20, we will implead the High Court as a respondent, and he will file his affidavit in opposition. Ministry also will file their affidavit. It will be assigned to a bench who knows this as there have the right form. To a bench who knows the matter the best.
My lord,
my lord, earlier, my lord, there was a decision. Earlier, there was a decision of the government to develop car parking underground, my lord.
Assuming the Maidan area is given. Do you think people will park their car and walk here?
No, Maidan area means, my lord, it is very nearby to the High Court.
No, they don't want to wait for the policeman to go inside. Every third day, from second floor, when we walk back from courtroom 16, every third day there is a fight, fist fight between drivers and the another driver, or one clerk and another driver, or the policeman shouting. How long he can keep on?
That's the reason, my lord, that a proposal has been given, my lord. The driver-driven car may be parked in those places. At least 300 car may be parked there, so that the congestion in and around our High Court 3 buildings area may be, my lord.
How do we say it's a driver-driven car or a owner-driven car?
No, that is there, my lord.
You should be first willing to accept some regulation. That unless we have that mindset, all right, stickers, red sticker cars will be owner-driven. Blue sticker cars will be driver-driven. So the blue stickers car will enter through this gate or this direction, exit through that direction. It doesn't mean that that advocate will be dropped straight. There will be 15 big bags. He has to stop. Somebody has to take the bag, etc. Congestion. Taxis. How many advocates are coming by taxis because of this parking issue? They may own big vehicles, but they park it at their home, take a taxi and come here. Taxis are coming inside. Most of these taxi people don't know which way to go in and out. Regularly, if the taxi man comes, is right.
Regular.
Whether to go left or whether to go right.
And if they come after 10, my lord, then it's a Lucknow Bulbulia case.
My lord, what happened, my lord? Even the car of the then Honorable Chief Justice was not allowed around the Victoria, my lord. It happened, man. So, my lord, there are certain things. I'm deeply obliged that your lordship has
file your affidavit,
yes, my lord,
clearly pointing out as to how the prayer of the High Court cannot be granted.
And my lord, about the,
They will file affidavit in
Your
reply.
lordship, may I?
they will not be able to
So
because
far,
I will be
High Court
suggesting.
prayer is concerned at the interest of the members.
No, it is in interest. High Court should go to the government for underground parking.
Who will give an undertaking that you will exclusively use it as a parking?
No, it cannot be, my lord. It cannot be. It cannot be ensured.
Driver driven cars are parked. You will say, what they will do for their food? Why 2 or 3 jalmuri stalls? What will happen? They will take it away in the evening. And one fellow will say, let me make puri sabji. 4 fellow drivers are hungry. They can't walk up to that Court Road and Old Post Office Road. They can't come to Old Post Office Road. They have to walk in scorching sun.
My lord, another aspect, my lord, it was reported in
Your
the
lordship,
Telegraph newspaper.
But we have to
Telegraph,
do
my lord,
something.
the Victoria Memorial is the pollution capital of the city, my lord. Because there are air monitoring stations in Calcutta.
No. We fully appreciate whatever. Letter here.
Your lordship, just beside, as an officer of court, your lordship, I'm proposing this just beside 2 things, your lordship. Multi-level parking, which is available throughout the country now.
You give the land.
Your lordship,
You give the land for the multi-level parking.
your lordship,
I have a suggestion.
You have got a building next to the SCB building, which is a Defense Department building, correct?
Yes.
Huh?
Yes.
I'm informed.
It's the Ordnance Factory Board.
Only 4 floors in the building have been occupied. From 5th, it is vacant, correct?
I'll have to inquire.
Oh, you find it. So you give that building to us. We'll have a bridge connecting
Your lordship, another thing.
from SCB to that.
Your lordship, just beside the Havra Bridge on the right-hand side, there is an entire more than 2 kilometer stretch empty land of Port Trust. The bus terminal
Nobody will
had
park
moved.
and nobody will park there and walk
On
back.
this issue,
Bus
That's
terminal.
2.5 kilometers away.
I moved long back, my lord.
The Bar
Authorities.
Association and the High Court could use that BBT Bagh parking area.
All right, you make a
Petition on that.
Propose that in my affidavit.
we have heard so and so all party.
Can 19 the diya tha?
Yes. You find you take photocopy, no? He is a party in person. You take a photocopy from him.
Scan copy diya.
These issues don't bring it to our notice. The division bench on 29th March 2022, among other things specifically directed, sir, hear the order. Among other things specifically directed, the writ petitioner who is appearing in person to file an appropriate application stating the issues which are still surviving in this matter, so that the concerned respondents can be duly respond to the same. It is submitted by the petitioner appearing in person that pursuant to such direction, he has filed Can 19 of 2022, wherein the following prayers have been sought for. Page 8 of the application, 1, 2, 3, 4, 5, 8 and 9. Thus, according to the petitioner, the above are the only reliefs which he seeks before this court in this public interest litigation. On account of the same, all other applications are closed and stand disposed of, except Can number 19 of 2022. The respondents the respondents in the said application are directed to file their affidavits within 3 weeks from date. Reply, if any, within 2 weeks thereafter. The High Court administration, the High Court at Calcutta, represented by the Registrar General, has filed Can 20 of 2023 pursuant to the resolution passed by the Hon'ble Safety and Security Committee of the High Court. In the said application, the first prayer sought for is to implead the High Court as a party respondent in this public interest writ petition, namely WPA 7987 of 2022. The said prayer is not being opposed by the writ petitioner who is appearing in person, and accordingly, the High Court at Calcutta, represented by the Registrar General, is impleaded as a party respondent in WPA 7987 of 2022. The second prayer sought for is to implead the authorities of the Ministry of Defence, Government of India, and the army authorities. We are informed that already the Ministry of Defence and the army authorities are parties to the proceedings, and in fact they are represented by their counsel. Therefore, such a prayer for impleadment of those authorities is not required at this stage of the matter. The main prayer sought for in the writ petition in Can 20 of 2023 filed by the High Court at Calcutta is with regard to providing parking place for the learned members of the bar. In this regard, the petitioner appearing in person seeks to file his affidavit in opposition. It is pointed out that the Victoria Memorial Hall has to be preserved, and in this regard, the petitioner refers to the various articles and the report submitted by NERI, N-E-R-I, NERI, full stop. In the light of the above, we direct the petitioner appearing in person to file his affidavit in the prayer sought for by the High Court at Calcutta, represented by its Registrar General, with regard to providing parking facility for the vehicles of the learned members of the bar. Such affidavit will be filed within a period of 3 weeks from date, and reply, if any, within 2 weeks thereafter. Full stop. In order to no, it's not it. In the opinion of one of us, within bracket TSS, if the matter is dealt with by a division bench consisting of honorable judges who are well versed with the area in question, it will augur well to all parties, and a solution to the problem can be found. Therefore, after the affidavits are filed, let the matter be listed before an honorable division bench, as the acting Chief Justice may decide, and the papers be placed for appropriate orders in this regard. Let the matter be listed for directions on 12th June 2023. Yes, sir.
WPA 16 of 2020, so moto by Justice Sanjeev Banerjee. Justice Arijit Banerjee. Where, my lord?
The problem is, Justice Arijit Banerjee is in the security committee.
I'm saying that matter be dealt with, please.
Not necessary.
Yes.
That's a suo motu. The court on its own motion concerning the Maidan. No, parking is not an issue there.
In fact, the matter came before us. We have adjourned it. They said the entire area is full of water logging. There are this plastic bottle stone, etc. So, very good.
There are many applications, even the bus operators, clubs, and all this. There are 100 clubs.
All applications are disposed of except can number 19 of 2022 and can number 20 of 2023. The direction for filing of affidavits within the time frame be complied with the concerned parties.
My lord, one kind indulgence.
Somebody wants a copy of your application.
Yes,
please give soft copies.
My lord, will there be any direction by your lordship about the shifting process? Because 20 years.
Not now. Let the affidavits be.
Let the state now. This is that issue. On that issue, let the state come before the lordship.
In Can 19, the respondents will file their affidavit.
Yes, yes.
Let it affidavit.
My lord, one another.
You ask him,
No, we have served them.
you ask,
We have served them 2 copies on the 13th. He's again asking for another copy.
Get a photocopy done and given. I'll get a photocopy.
My lord, I beg this a kind indulgence, my lord. My lord.
Yes.
Logging. What has happened, my lord? I have misplaced due to water logging in the room. All the records have been lost. So kindly give at least 1 month's time to salvage, because I have not been able to today.
I'm submitting to Lordship, I appear for the Kolkata Municipal Corporation. The writ petition was for the direction upon the authorities to initiate all steps and measures that are necessary for smooth flow of sewage, drainage, stormwater of the Kolkata and Howrah. We submitted a comprehensive report in 2015. The matter was still there, it was not taken up, not considered. Now the matter once again, since it's an old matter, brought in the list. Then Your Lordship was pleased to direct us to submit the current report. We have given a current report. What I am suggesting, my lord, the matter could be disposed of this, and if anything, my lord, new issue is raised,
because
then that could be raised.
see, now that your papers are not traceable, etc.
Let them file their latest status report.
Correct, sir. He will file it.
Yes.
And it is from 2007, the matter is there. So what you do is, based on that, where is that status report?
Last status report, we have submitted. By an affidavit, my lord, that report is on record, possibly, my lord. We have
Where is that report?
the last date report.
You get that report. You make one photocopy and give it to him.
Just put it. I have just.
We don't have. We don't have.
21st April
this writ petition.
2022.
Sir, take down.
2022.
Take down.
21st April 2022.
This writ petition has been filed as a public interest litigation, pointing out various issues with regard to the maintenance of hygienic atmosphere in the area falling within the jurisdiction of the Kolkata Municipal Corporation. The writ petition has been pending since.
And Howrah also.
From 2007. And the corporation has filed the latest report dated 22nd April 2022. The said report is taken on record, a copy of which has been furnished to the petitioner appearing in person.
Yes, ma'am.
Since by efflux of time, there would have been a lot of change of situation. We direct the petitioner to examine the report, and if any further grievances are there, the petitioner shall bring it to the notice of the chairman of the Kolkata Municipal Corporation, who should take appropriate action on the report, on the representation with regard to any fresh issues which are pointed out by the writ petitioner. In the event the action taken is not to the satisfaction of the writ petitioner, it will be open to him to avail the appropriate remedy in accordance with the law.
My lord, other than Calcutta, it was Howrah also in the main
Calcutta Municipal Corporation as well as
Howrah Municipal.
The chairman, but it will be municipal commissioner.
Not chairman, municipal commissioner.
My lord, Howrah Municipal Corporation may kindly be included.
Disposed.
My lord,
next.
I don't know, 13.
Lord, I am for the petitioner, Lord.
Yes.
Lord, the matter is relating to development and upliftment of a rural hospital. PHC, Public Health Center, my lord.
Pathetic condition.
My lord.
Pathetic
condition, my lord. As what happened, my lord? The issue find its root in the year 1977.
Now, what is the position No improvement.
No improvement has, in the last occasion,
Hmm.
the Honorable High Court was pleased to pass a solemn order. And by virtue of that solemn order, initiatives has been taken, my lord. And currently, 6 beds, 4 doctors, 4 nurses are there. And apart from this thing, outdoor service is running, emergency service is running, and 1 labor room service is running. We are satisfied, and the state government is quite kind enough to comply the order, solemn order passed by this honorable court, my lord. Our humble prayer before this court is, since there were 10 beds, at least 10 beds should be there.
But is there place for keeping 10 beds?
My lord, it was there at the time of inauguration.
Hmm.
It was there.
Then what happened to it? Went off.
My lord, this is my humble prayer before your lordship, my lord.
Sir, the primary health center is very, very important.
Local Chatterjee is appearing in this matter.
Maybe whoever is appearing says,
That affidavit, my lord, it is not running, my lord. It's full.
no, learned friend also agrees, but he says 6 can be increased to 10.
My lord, the
Subject
space,
to-
the area of the, my lord, primary health center, my lord.
All right, by this writ
But we have
petitioner,
filed the affidavits in this matter.
the petitioner has brought to light the pathetic condition of the Tahirpur Primary Health Center, which did not have even the basic facilities to treat the local population. Directions have been issued in this writ petition from time to time, and last of such direction was issued by the division bench on 14th March 2022. The learned advocate appearing for the petitioner submitted that after the said direction, there has definitely been improvement. 6 beds have been provided, 4 nurses have been appointed, and other facilities have also been provided. However, it is his endeavor that, however, it is a submission of the learned advocate that at the time of inauguration, there were 10 beds, and therefore the number of beds should be increased from 6 to 10. The our appropriate respondent has filed a report in the form of an affidavit on behalf of the 4th respondent, which is taken on record. So far as providing healthcare facility, it is the duty of the state and a constitutional obligation cast upon the state to provide healthcare to its citizens. It is not for this court to remind the state government as to what are the facilities, medical facilities, which have to be provided to the public. A primary health center should be fully equipped to handle any medical situation, any medical emergency in the locality. And if the primary health center is not fully equipped, it would tell upon the state government and also would result in pointing out the failure on the part of the state government to provide adequate health care to its people. Therefore, we would direct the principal secretary of the health department, Government of West Bengal, to ensure that the primary health center concerned in this writ petition is fully equipped, and if 10 beds can be accommodated, it shall be done so, and periodical monitoring of the primary health center be made to ensure that the facilities provided therein, including the manpower, is maintained in a proper manner. The principal secretary health department shall also issue a directive to all the primary health centers in the state, so that wherever there is improvement to be done and there is a deficit of staff or infrastructure, the same should be reported to the government, and the government should provide such facility within a time frame. With the above observation, the writ petition stands disposed.
Deeply obliged, my lord.
Next.
Item number 14.
Why you are surprised, huh?
For the respondent Union of India.
Otherwise, the matter will be. Is the matter.
CWC. What do you mean?
Yes, ASG, what is this?
Well, I am for the petitioner, my lord.
You are for the writ petitioner. What is that you want, madam?
My lord,
Over Damodar Valley Basin. Immediate implementation. You went to
it is not to expedite the hearing of
No,
the.
that's how the order
Yes, my lord.
reads.
That is.
Now, who are the respondents who have to respond to this prayer?
I appear for the state respondents.
I appear for the Union of India, Milord, but we are not the primary answering respondents, Milord.
Who will be the answering respondent?
The state, Milord, because
I appear for the CWC.
And the Supreme Court has directed us to hear the matter.
There was a direction in 2016 to file an affidavit. This is a whole matter. Il Ashok kindly grants me a week's time, Milord, so that I can come up with instructions in this matter.
Where is the Supreme Court order, madam?
Right.
You file an affidavit, but the affidavit will be accepted subject to payment of cost.
And I'm playing apology.
Other
because
option.
only one copy is there, my lord. Two orders are there, my lord.
So advice for appropriate redress of this court. Thereafter, you mentioned it and the matter got listed.
My lord, instead of my lord filing my detailed project report, my lord, the answering respondent, my lord, the government of West Bengal, my lord, instead of approving this to execute this project, my lord, they execute a separate project which is similar to this project, my lord. And in that project, my lord, that is the project of state of West Bengal, my lord. In that project, my lord, already fund has been disbursed, my lord, and everything has been received by the government of West Bengal, and they are implementing that project.
So
But this project,
you don't want that to be implemented.
no, my lord,
In addition to that, you want this.
yes, my lord. Presently, the situation is like this, my lord. The work which has been explained in this project, my lord, the project already initiated by or it is in execution by the government of West Bengal. Similar work of this project, my lord.
Then when was this execution happened? After you filed the report?
Yes, my lord. After filing this detailed project report, my lord, a similar kind of project has been approved, which has been
No, that similar kind of project was approved after you filed the report.
Yes, ma'am.
Then you have to bring that fact as a supplementary affidavit. How will they respond to it? Because this is a old matter. Or you can do one thing. We will give you liberty to withdraw this writ petition. You come for the fresh writ petition, bring all these facts into consideration because something has happened post 2016, which even if you file a supplementary affidavit, it will be just adding to and it will be a old matter. If you file a fresh matter, bringing all what has happened subsequent, that will be ideal.
Then my lord, kindly adjourn this for this day only because I have to take instructions from my
Petitioner.
client. Yes, my lord. My lord can take.
We have heard so and so. The learned advocate for the petitioner submitted that certain subsequent developments.
My lord, adjourn it for a week.
Subsequent developments have taken place after filing the writ petition. However, the said developments have not been brought on record by way of a supplementary affidavit to enable the answering respondent to respond. The learned advocate for the petitioner prays for time prays for a week's adjournment to enable her to get appropriate instruction from her client. List the matter on 24th.
I'm deeply obliged.
On that aspect alone,
Fine.
it is you advise him because he may not know that order you give to Supreme Court order. Next.
I don't know, 15 and 16.
In this matter, Millard had granted us liberty, Millard, to file affidavit, Millard, because we had taken a lot of steps, Millard. This is with regard to Rare Disease Act, Millard.
Muscular
Millard,
dystrophy.
my lord. Millard, we have already framed a policy, and subsequently there too many other aspects we have gone into, Millard, and for the development of the entire thing, and Millard, to provide better benefits under the act to the Millard, the persons who are suffering from this. But Millard, that has been ready, Millard.
But what will be the approximate number of people who are affected in the state?
Millard,
is there any census taken on that?
My lord, they were the petitioner by virtue of the last order, which was passed by your lordships. The petitioner were directed to share a list.
We have given a list.
They have shared it with the state government. Millard, we don't have that particular list now. And Millard, what our predicament is, Millard, we have already affirmed the affidavit, Millard. We have exchanged, but Millard, by post it was coming, Millard, has not reached.
Reached it. Okay.
Millard will kindly give us a breather of a week,
No,
Millard. Next week we'll come with the entire. We have already served, Millard, whatever.
See, you are a society. Huh?
Yes.
That society might have been formed to protect some of them, but how do we identify these people unless they come to treatment for a
It's
government?
difficult, but that's so glad we have given a list. So far, our knowledge goes, Millard, we have prepared a list. We have handed over to them, Millard. Well, first steps they need to take, Millard. They have to issue certificates for all those people, Millard, in terms of the Act of 2016. And then, Millard, there is a section 25 provides for some certain benefits, Millard. Millard, I don't say, Millard, they have to provide all the benefits today. But for the step by step, Millard, we have to survive. Millard, we need, Millard, free medication, Millard. That's the first steps they need to take, Millard.
Because it's a degenerative disease.
Yes, Millard.
Millard, there
Days
is no.
go by.
Yes, my lord, there's no cure. My lord, it's only palliative, and whether, my lord, the pace can be decreased, my lord, of the degeneration. So, my lord, I'll tell you, lordships, what's happened here. My lord, there is a portal, my lord, which has been set up. My lord, it is being linked, my lord, with the center. So that, my lord, there is, my lord, a record, my lord, maintained, my lord, of persons, my lord, who are suffering from this disease. The portal has been set up. I'm told, my lord, the API is to be put in place, so that, my lord, the linking, my lord, happens. It will take about another month, my lord, for that to happen. Both center and the state, my lord, are working on this. My lord, Bengal, my lord, compared.
Very happy to know.
My lord.
Yes.
My lord, in fact, I must tell your lordships, my lord, we had a sitting, my lord, the officials from the center, and my lord, I would, my lord, say one of the reasons it's worked, my lord, because a gentleman who came had worked with my deceased father, my lord, at the sense. So, my lord, my lord, got it moving, my lord, that should, my lord, happen. Second, my lord, a list.
And these people have to log into the portal and give their.
Correct, my lord. Otherwise, my
lord,
lord,
the society will take care. You give.
Millard, we have already, Millard, handed over.
Yes, my lord,
Wait, sir, you hear and respond. This is wrong. You have to hear the other side and respond. He says there is a portal going to be put in place. APA will be given. It will be operational within a month. So the society should take upon itself the responsibility of giving wide publicity, getting the names, because people will be from marginalized members of society. You upload the details. I have given the list. I have given the list. You keep on saying the same thing.
Last few occasions, Millard, the same submission was made by London Advocate General with due respect, Millard.
We are hearing that
with due respect to London Advocate General, Millard.
Truly value
last 3-4 occasions, the same submission he has made from that side. I understand, Millard, his difficulties. Millard, we also, Millard, he must understand our difficulties. Millard, these people are, Millard, dying every day, Millard. They need some protection to survive until this website is prepared. All these formalities are done.
May I now indicate? Now, my lord, a list of 34, my lord, were given, my lord, to me, my lord. Now, my lord, I have, my lord, had that examined. My lord, 11, my lord, have been registered and their names, my lord, uploaded. They came physically, my lord, have, my lord, got registered. They were checked. my lord, certified, my lord, to be suffering from muscular dystrophy. Their names, my lord, have been put up, my lord, uploaded, my lord, in, my lord, my lord, panel meant for CSR funding, because that's the scheme, my lord, that, my lord, the center had promulgated. So, my lord, that has been done vis-a-vis 11. My lord, the total of 34. Now, my lord, there's registration. There's registration as well as, my lord, uploading. There's registration as well as uploading for, my lord, these 11. My lord, I can give the names also.
No, not required.
Now, my lord.
So what about the
Yes,
remaining?
now, my lord, out of
23?
that, another balance 11, my lord, we have, my lord, found 6, my lord, not to be suffering from muscular dystrophy. But, my lord, 5 others have been found to be, my lord, suffering from muscular dystrophy. My lord, hopefully by today or tomorrow, my lord, their names will also be uploaded.
Very good.
My lord, the balance, my lord, have not come to the center. My lord, I can understand, my lord, they obviously, my lord, if they're suffering, it's going to, my lord, be difficult for them.
Or some family member can come.
My lord, yes.
But
my lord,
they have to
but
be
yes,
examined.
examined. That's the problem, my lord, because the Center for Excellence is, my lord, our, my lord, old PG hospital, my lord, yeah.
SSK.
Yes, my lord, SSK. My lord, which has, my lord, which is designated, my lord, by the.
Let the society arrange for transportation.
Let them provide this.
No, you are.
In terms
you
of
are
the
come here,
statute, they have to do it free.
They will do it free, but assist them in
Yes,
bringing him.
most certainly, well, we shall assist them.
See, these five people, they will register. Others who needs to be certified, you arrange for transportation of them, some taxi, etc. You are an organization, NGO. You can get some CSR funding somewhere, and you arrange for that.
But we are not getting any such benefits, Milad. But if they provide
Who
that
paid for all these
ambulance,
papers?
Milad, we are.
And is there any this? Then the society is who's representing the society?
President of the society is the second member in the writ petition.
What is his avocation? What does he do for his living?
He is
PIL.
in a private company. He works for a private company, but he does not have the funds to.
Then how to bring it? Suppose they are not in Kolkata. How to be brought to SSK? Yes, Advocate General. If those people have to be examined here, how to bring them to the PG
My
hospital?
lord, if they can organize, my lord, their travel, we'll reimburse the cost of travel. That can be done.
Lordship, I shall give a small example. The second petitioner, Lordship, his son had applied for a UDID card 2 years. He has not received the card. There have been ample reasons given. Lordship, the first requirement at the moment would be the UDID cards for all the patients. If they are identified through the cards, then they can next step.
Now,
Why the second petitioner, my lord, is in the list, my lord, of 34 uploaded, my lord, for my lord CSR funding. And my lord, once that
No,
portal,
that card, whatever this.
my lord, the card happens once that linking, my lord, of the portals, my lord.
How long the linking?
My lord, 1 month, my lord, I've said on that, my lord, API. My lord, Union of India, my lord, had filed an affidavit saying, my lord, steps had to be
All
taken.
right. Before this e-card business came, they were all physical cards. Like
Yes, my lord, there was this, my lord,
so at
physical.
least if you give them a temporary physical card,
Yes.
some benefits can be got.
My lord, as long as the center's okay with it, I have no problem, my lord.
My lord, the scheme is such, my lord. UDID card is once they have been diagnosed with this rare disease, my lord, they are on the portal and they get these cards. And my lord, they can use these cards for medicines, for traveling, and so on and so forth. Now, my lord, as far as diagnosis is concerned, my lord, if they are suffering from that, they will come to our center of excellence. They will diagnose, and as soon as that card is not required, we will upload that, and we have already sanctioned 1,62 lakhs. We have already sanctioned for 8 such patients whose names have been uploaded. Now, and we have also increased the upfront amount from 20 lakh rupees to 50 lakh rupees. This is what is on affidavit. It will be on affidavit. I am not saying anything from the company. So, what I am humbly submitting, it is nobody. It is a welfare litigation.
When is your affidavit likely to arrive in?
My lord, affidavit, my lord, we have already, maybe within 2 days, they have already dispatched it. We have got the scanned copy. We have served it.
We'll keep this next Monday. You don't have to file an affidavit by the whoever is the competent authority director. You file a report. Whatever you say in 2 pages. Don't make it 10, 15 pages report, 2 pages report with this 34 people, 11 people, 5 people, 6. Give those names. One advance copy can be given. If on Friday that report can be.
My lord, we have already got affidavits. We can serve them. But what I indicated about the report, we'll put it, my lord, the
in a
list
consent.
in a one page.
What is this affidavit?
Our last order, your lordships kindly sees. My lord, we were requested to file, my lord, affidavits, my lord, giving, my lord, the status regarding the portal. And my lord, those were the submissions. And my lord, I think, my lord, that's what's recorded in the order. We'll file
The
that.
affidavit filed by the state government.
My lord, there are two affidavits.
Only one more thing,
State government. The affidavit directed to be filed with the state
We
government
provide the traveling
is taken on record.
expenses. Lordship,
Taken on record. The learned advocate general has submitted certain that 34 persons have reported that they suffer from this rare disease, out of which 11 persons have been identified to have been affected with rare disease, and their names have been included in the list to make them eligible to receive appropriate benefits. It is submitted that some more persons are also in the process of being identified and enlisted. It is further stated that the funds can be paid only if their names are registered in the web portal, and it will take a minimum of 1 month for the web portal to become active. The affidavit, the learned Deputy Solicitor General appearing for the Union would submit that the affidavit of the appropriate authority of the central government has been affirmed at Delhi and will be filed on the next hearing date.
Millard, we have served the copies, Millard.
Next hearing date, copies of which have been already served on the learned advocates for the parties. Let the appropriate authority of the state government file a concise report with regard to the number of persons who have already been registered, number of persons who are found to be not suffering from muscular dystrophy, and the others who are in the process of being identified and registered. Let this report be served on the learned advocates for the parties by 21st April 2023. List the matter on 24th April, higher on board.
My lord, may I just seek one indulgence? Instead of 24th, could it be 25th, my lord?
25th.
25th.
And if your lordship shows the desire, my lord, we can spend this money from our so far this.
No, let us see. On that day, suppose we are able to, but we have to see from which districts they come from.
Yes, my lord, I have, my lord, been having a look at
One
it.
of the suggestions that we had given, Lordship, there is one center of excellence in the eastern region, covering all the states of the eastern region. Lordship, we had prayed that there should be more center of excellences in the eastern region. It is not possible for a patient from Mizoram to come to Calcutta for this, or it would not be possible even within West Bengal to come from North Bengal. They are not mobile persons. They must be.
Only solution is, but the center of excellence can move to their place.
Yes, that.
But what about the equipment?
That they don't have.
That is
In terms of step, they are also entitled to
if it requires only physical examination, it is fine. But
My lord, I'll check on that, my lord. I'll check on that.
if suppose some equipments are required,
Your lordship, the identification at that stage, if the center of excellence goes to them, then it would solve a lot of problems thereafter for
Lord,
the.
may I-
AG will examine.
Yes, my lord, may I make one suggestion here? My lord, the center, my lord, we are again trying to work together, my lord, in this. My lord, funding, my lord, has been recognized, my lord, has to come from the center. My lord, this is, my lord, there are judgments, my lord, on that. So, my lord, it's on the basis of a diagnosis done, my lord, which has to be done by the center of excellence. Now, my lord, which institutions are designated as centers of excellence, my lord, is to be decided by the center. So, my lord, they can, my lord, also look at others, other than, my lord, the one, my lord, in, my lord, Kolkata. In
the
fact,
learned
Kolkata.
Deputy Solicitor General shall also provide necessary information as to where the other centers of excellence are located.
Can be located.
In our
Can
state,
be
only
located,
one
Millard,
is there.
kindly, because the instruction we have, as of now, Millard, we have only one center of
No,
excellence.
in West Bengal. What about neighboring states?
Neighboring states, my lord, we don't, but as far as West Bengal is concerned, my lord, as of now, we have only one, my lord. So, my lord, I may take instructions as to what we are doing, whether we can and what we are doing for establishing more centers of excellence.
That's one at least in northern part of the state.
My lord, I bow down, my lord. My lord, I shall take
Somewhere,
instructions.
obtain necessary instructions as to whether the center of excellence, which is at present located only in Kolkata, can be also established in other parts of parts of the state, considering the remoteness of certain districts.
And there is a Kollani AIMS.
This
We had given suggestion on
this is required, considering the fact that at times the persons who are suffering from this rare disease will not be able to travel long distances.
And my lord, all India, they have 8 centers of excellence.
Difficult.
There is Kollani AIMS in Kollani.
Total 13. My
There is an
instructions
AIMS,
are
Malad. They
there
can
total
treat
13 in
this
it.
hospital as Malad, central excellence, Malad.
But how much funds is required for that, we don't know.
We shall file a report, my lord.
Let
Because,
this
my lord,
come, we'll see. At
crowd
least for
fund-
this 34 people,
Yes,
34 minus 5.
My lord, crowdfunding has also failed.
Crowdfunding will not do.
My lord, it's been tried by, my lord, the center. My lord, that has failed.
Now, out of 34, 6 are not eligible according to that.
Correct.
Yes, sir. Yes, sir.
Let us see.
the corporate social responsibility. That's one area which has not been taken into account. That is, the companies are bound to make a payment on account of this. But if that fund could be somewhat be given to this particular sector.
My lord, we have taken into account. We have affirmed on oath in our last affidavit, my lord. We have taken that also in. We are keeping no stone unturned, my lord.
My lord, CSR funding, your lordship's away. My lord, it gives a range. My lord, it's up to the companies, my lord, to decide where to go. And in fact, my lord, what has started now, my lord, is, my lord, research in India itself, so that, my lord, these palliative drugs, my lord, can be made available, my lord, at, my lord, low cost, my lord, generic drugs. Otherwise, my lord, there have been cases.
But at times, more than one member of the family will suffer from the same disease.
It can happen. Absolutely.
There have been cases where
Yes, there are
all the siblings.
Correct.
all the
It can
siblings
happen.
have the same
It
disease.
can happen.
That has happened in this particular case also, we know. And the saddest thing is the caregiver, lordship, here in this particular case, the mother had to give up her job to look after the children because
Obviously.
both.
Let us see 25th, let it come.
I'm grateful, my lord.
Afternoon, original side. We'll come back at 2:30. Original side. Yes.
Original side matter, item number 1, public interest litigations.
My lord, this 1 to 7 are the similar matters, my lord, of the public interest litigation. I'll just indicate, because this is my lord is hearing for the first time these matters. Now, this is with the state government has filed a application under Article 226 with regard to a company called Overland. It was doing some cheat fund business to protect the depositors. Now, there were several orders passed from time to time. Now, so far, and there was an administrator, special officer appointed, a former judge of this honorable court. I appear for the special officer. Now, amongst other application, which is the last one, is GA 38 in the list. What happened? The special officer, pursuant to leave granted by this court, has sold away one property and taken them for depositors, because property was with the company. It was sold, money taken. Now, subsequently, it transpired on the state's application that the property which was sold was a vested land. So the sale has to be cancelled. It became a vested land. So for the sale, a consideration of around 44 crores and odd was given to us, along with stamp duty, registration fees, panchayat tax, and every tax was given to the state. Now, when the sale got cancelled, so order was passed on us to refund the consideration.
Sale proceeds.
The sale proceeds with interest, whatever, the order was passed. See, I hold the office to pay off the depositors, whatever the order was passed. I have from time to time paid away the sale proceeds to a great extent. Now, what exactly happening? The stamp duty and registration, panchayat tax and other tax, which the government has taken, so that must come back. 2015, the money was paid to the government. So this must come back. So this is the application, which is GA 38, is precisely the prayer is the state should refund the money because the conveyance was set aside. So he cannot take the benefit of that conveyance any further. Now, in this GA 38, that is a prayer, state should refund the money of stamp duty, registration fees, panchayat and other taxes. Their state matter was heard. There's a judgment on the Supreme Court also. State is agreeing to refund. Last order records of the
date of the order?
Yes, last order 17th of March. 17th March 2023. This is a one page order. The 17th March 20. May I hand up a copy of the order?
Learned Counsel for the state has submitted that the state will refund the stamp duty registration fee and the matter is under process.
Now, to take out money from the government is, this is happening for last 3 months. That is the problem.
Let us
We
hear.
sought for from the concerned person, my lord, and that's the communications from us. The learned advocate on record, my lord, wrote to the kindly give us a couple of weeks time, 2 weeks time. 2 weeks.
It's around 35 lakhs and odd, the principal. Now, we also asking for interest of 6%.
But how come the vested land was sold?
It was.
Well, this issue, I am for the restaurant of 4 and 5. This issue is before the Supreme Court, Honorable Supreme Court, where only apart from these, all other issues to be decided by the Honorable Supreme Court, including the question of vesting.
Now, state, that's that main question arose, how can a vested land be sold? But if I look into the orders, the sale order was passed.
Fix it on 1st May. 2 weeks he wants.
The order of the order was sale was passed in the presence of the state lawyers. Now, they never objected.
All right, now that it's
Whatever. Yes.
Under West Bengal Land Reforms Act, any institute or an individual can retain only 24 acres of land.
Okay.
So this company, this cheat fund company, was holding beyond ceiling surplus.
Whatever. Those are chapters.
Reference may be made to the order dated 17th March 2023, in which the division bench has recorded the submission made on behalf of the state, that the state will refund the stamp duty and registration fee and other necessary fee paid by the applicant and the matter is under process. The learned advocate appearing on behalf of the state has produced before us a letter written by the Office of the Legal Remembrancer, Government of West Bengal, dated 30th.
I'm sorry to bark, my lord. That would be, my lord, advocate on record on the left-hand side, my lord. will be
Advocate on record, State of West Bengal, not a legal remembrancer, dated 30th March 2023. By which the documents which were requested were furnished. The learned advocate appearing for the government would submit that 2 weeks' time may be granted so that the refund can be processed and the
Instead of refund, my lord,
That's
my lord, we cannot take the decision on behalf of the officers. My lord, let them take the decision, my lord.
2 weeks further time may be granted. So to enable him to revert back with specific instructions.
Yes.
Let the matter appear on 1st of May 2020.
We will make some observation whether last 3 months, if not more, this process is going on.
As you rightly said, getting it out of
Yes.
them
Yes, that I know.
next to impossible.
All the matters.
Let us see, let us hope for the best.
Yes, Mr. Mondal is there, Mr. Dhar is there. I believe this should be done.
Yes.
Because it's going on for quite some time.
All the matters, not even
Here also.
Yes.
I-
No, all matters can appear on the same day. Manoj.
Yes.
This is the most
Item 1 to 7.
1 to 7.
This will be a common order.
No.
Item 1 to 7, 1st of May.
First of deeply applied.
Deeply applied.
Item number 8, new application tax matters.
How many days delay? 20 days. The respondent served no affidavit of service. Where is Mr. Tilak Mitro? Let the matter be listed after notice is served on the respondent and affidavit of service is filed. Next,
Item number 9,
this is also same. Last occasion, I think we granted time. Same order.
item number 10, application adjourned.
I'm for
Not
this
I am for the
assessing
appellant,
matter.
Lord. There was a delay of
But
1,000.
This is the order passed by the assessing officer for the 2 year for the assessment year 9-10 and 10-11, my lord.
What
There
is
is no demand has been raised, my lord. Subsequently, because what happened, my lord, the CIRP proceeding has been initiated, that it has been new management has been taken over. My lord, earlier the respondent is the Rohit Ferotek. The Tata Steel Mining has taken over the company of the Rohit
We
Ferotek.
have filed substitution application also, my lord.
this appeal filed by the revenue is directed against, there is a delay also,
1,227 days, my lord.
then do strike out that. We have heard so and so, so and so. There is a delay of 1,227 days in filing the appeal. Though the reasons assigned in the affidavit filed in support of the condoned delay petition are not satisfactory, on account of certain subsequent developments, we are constrained to exercise discretion and condone the delay in filing the appeal. Para. This appeal has been filed by the revenue under section 260 capital A of the Income Tax Act 1961, challenging the consolidated order passed by the Income Tax Appellate Tribunal C Bench Kolkata dated 12th October 2018 in ITA numbers 262 and 263/KOL/2018 for the assessment years 2009-10 and 2010-11. The revenue has suggested the following substantial questions of law for consideration. Page number. only
Page
one
5, paragraph 10.
question of law. Page number 5. In para 9, there is only one question. We have heard so and so. The learned advocate appearing for the respondent has submitted that the assessing officer, taking note of the amalgamation of the assessee with Tata Steel Mining Limited by virtue of order passed by the NCLT dated April 7, 2022. The assessing officer has modified the demand raised on the assessee as nil by order dated 15th March 2023. In the light of the above, the revenue cannot pursue this appeal any further, and for such reason, the appeal stands disposed of. Disposed of. The substantial question of law suggested is left open.
Grateful.
Next.
Item number 11.
For the respondent.
Hmm.
I may be allowed to serve this affidavit.
What is that affidavit, sir? Penny stock matter. Penny stock matter. Is it a penny stock matter?
No. Yes, actually what happened in last occasion, they applied for condonation of delay.
Mr. Tilak Mitra.
And it was,
Hmm.
and the delay was about 1176 days.
Hmm.
An earlier occasion, your lordship has passed the order where the 1105 days was there. And
That we have dismissed it. That order is there.
Same order.
That is recalled. Now we have to dismiss it following that Swati Bajaj. Now that earlier order we have dismissed section 5. Similar type of orders. No. They have said they have taken to take advantage of that one-page order. We have heard Mr. Tilak Mitro, Leonard Senior Standing Counsel for the Appellant Revenue, and Mr. So-and-so Leonard Counsel Advocate appearing for the Respondent Assessee. There is a delay of 1176 days in filing the appeal. We have perused the affidavit filed in support of the petition. We find that sufficient cause has not been shown for not preferring the appeal within the period of limitation. Further, we note that that decision to file this appeal was taken much after the decision of this court in PCIT 5 versus Swati Bajaj 2022 SEC Online Calcutta 1572. Thus, full stop. Thus, we are not persuaded to exercise any discretion in favor of the appellant revenue. Consequently, the application is dismissed and the appeal stands rejected. Next.
Item number 12, specially assigned matter.
Yes,
please, your lordships. I am for the private response. I represent the High Court Administration. The Lord would be pleased to take up volume 3 of the paper book, Lord. The order impugned that was passed by the writ court.
Volume 3.
Volume 3. Page 423.
Yes. (423).
The facts are narrated, my lord. That's why I am not placing it. Your lordship will just look at it and then place.
পেতে পারবো না ঠিক আছে তখন বসেছিলাম এরপরে দুটোর সময় তো ম্যাটার ফিক্সড আছে dictation বলেন কত বলেন থ্রিতেই আছে বোধহয় নাকি দেখে না হ্যাঁ ঠিক আছে ঠিক আছে হ্যাঁ ঠিক আছে
Yes.
Kamla, the writ court upon calling for the records found glaring infirmities in the action taken that is recorded in the order based on the documents that were produced.
No
Those
reason, no reasons given.
no reasons given. Now, my lord, in spite of that, the writ court dismissed my petition on the ground of delay. Now, the only question for consideration by my lords would be whether there is really any delay, and if there is some delay, whether that would have the effect of throwing me out of the court when there is glaring infirmities in the action taken. But the first humble submission that I'll be making is that unequals have been treated as equals. There was no scope of giving 2 marks extra and bringing persons who were not qualified within the zone of consideration. That is my first humble submission. Now, once that happens and no reasons are given, whether I can be thrown out on the ground of alleged delay when really there is no delay. Now, my lordship would be pleased to come to my grounds. That would be volume 4.
Page 458, Lord. Ground number 12.
Yes.
For that, the Honorable Single Judge has observed that the writ petition has been filed more than 8 years after the result of the concerned examination was published in the year 2009, without noting that in the year 2010, the appellant writ petitioner had filed an interim application for addition of party before the Supreme Court. And after the said application was dismissed as not pressed, he filed an application for recalling the same in the year 2012. And after dismissal of the writ petition under Article 32 of the Constitution of India in 2016, the writ petition was filed 2 years later. Lord, I beseech your Lordship to consider this aspect of the matter.
Now, can you give us some dates?
Lordship.
On what date was the select list published?
Lordship.
Or even from the date on which Viva was conducted?
Lordship. That there should be a list of dates, and list of dates. There will be a list of dates. Lordship gives me a minute.
Probably in the index itself, it may
Lordship. Page 312.
312.
12.
Volume?
Volume is, my Lord, 3.
It starts at 308.
My Lord.
Notification on
Yes.
31st March.
But your Lordship,
2000.
the list of dates is at page 312. My Lord. It will be easier for your Lordship to come to page 312.
Yes. 2009 March, 131 vacancies. 16 vacancies for direct recruitment. So the petitioner is a candidate who applied from the bar.
From the bar.
So 15/4/2009 will be the relevant notification.
Lordship.
So 131 plus 16 plus 26.
Yes.
153 candidates, including petitioner, participate, written test and direct, scheduled on 29th June, 30th June, 7th July. Result was published on 21st August 2008. Petitioner secured 13th position. Registrar General intimating 3 more candidates. This was on 28/8. Who had obtained 2 marks less than the pass mark in a subject would also be called. Result in respect to candidate other is required shortly thereafter. Petitioner obtained 17th position overall assessment of so and so.
And 9/9/2009, your Lordship will note, depend upon the final order of the Supreme Court in the pending writ petition.
That's where he filed a petition for addition of parties.
Addition of parties. In 2007, SLP. The SLP was disposed of in 2016. And we came before the writ court within 2 years.
Now, this addition of parties, that is the candidates who, according to the petitioner, secured less than, 2 marks less than the qualifying mark. He wanted them to be added as parties.
No. He himself, the petitioner.
He wanted to implement.
Actually, my Lord, what I could understand, it was a mistake. It was a mistake, but And then, and
See, that is a larger issue, sir.
that is a larger issue. But the point is not there. Point is not here whether there is really any delay after the 9/9/2009 document.
See, his cause of action, in fact, has arisen on 28th of August 2009,
Lordship.
when those candidates were permitted to be called for viva voce.
Viva voce. But then at that point of time, he had no knowledge. That your lordship will see. He had no knowledge. That is the order records, the writ court order records that. He had no knowledge that they were also being brought in. I'll come to that position, that portion of the order. But my lord, 9/9/2009, this document, my lord, meeting of the selection board.
Seeking my lord 5 minutes leave.
Yes, yes, sir, please. So after withdrawing the application, once again, he filed an application to recall that order.
Yes.
That was dismissed in 2011.
2012. But my lord, I would be, lordship will not look into that aspect, but would look into only the selection board's document, 9/9/2009 document.
There are two issues, sir. In fact, the observations made by the learned single bench with regard to the manner in which the selection board proceeded.
Yes.
Essentially did not give you any relief. The learned judge proceeds on the basis reason should have been given, administrative orders. Then he stops with that.
Yes. And there we join issue and come before my lord. Now the question is, lord, whether after the meeting of the selection board,
he should have consulted.
Lordship
He
will
should have
kindly come to
consulted.
9/9/2009
See,
document.
the problem is, there also once again he committed a mistake. In 2011, 12 to recalling application was dismissed. Is your client here, sir? He's not here, no?
Probably not. I'll check. I'll check up. But Lord, before that, your lordship will kindly come to volume. Lord, one more thing, Lord. This I must, from experience, your lordship has better experience.
No.
But the question
All of
is
us have got,
that when we look in retrospective, we understand, yes, there was a mistake. But when it happens, we have no idea that this is happening. But the question is whether after 9/9/2009, selection board saying that this will depend upon the final order of the Supreme Court, which ultimately culminated in 2016. So till 2016, there is no limitation. Kindly comes to page 99, volume 1.
Page 99. Volume 1.
Volume 1. Lordship. এটা কবে ডিসপোজ অফ হলো সেটা বলো 2016-তে সেটা আমাকে বলো Lord, that portion after your lordship reads, I'll just
Yes.
Lord, there specifically the selection board says, in view of the order dated 13/1/2009 passed by the Supreme Court in WP Civil, for the time being, only 16 persons from the panel will be appointed. The fate of the other two successful candidates in the panel will depend upon such further order or final decision that may be passed by the Supreme Court in the said pending matter. But once this happens, I believe the entire period
should be excluded.
I'm grateful. That's what my humble submission. So 2000 now, when the SLP was 2016, So 2016, till 2016, I cannot do anything even if I come to the writ court. Whatever I do, I cannot. Because
what was subject matter of Supreme Court was the issue regarding fixing a benchmark for the Viva OC.
that's right.
That's a larger issue,
That's a large issue.
especially for candidates who appear from the bar. But here, the issue which the writ petitioner projects is permitting ineligible candidates to sit for the Viva OC in spite of the fact they were unsuccessful or did not achieve the minimum qualifying mark in the written test.
But my lord,
His cause of action arose at that juncture.
even then, Lordship will appreciate, my lord, they are impinging upon each other because of this selection board's decision that we cannot do anything. Now, once this decision is taken, can I come before the writ court and get any order from the writ court?
Probably that is why he wanted to implead himself there.
That is the reason.
But then why did he withdraw that application?
My lord, it happens because nowadays it's much easier to look into what is happening through the net and all that. Earlier, from here to Supreme Court was a really difficult proposition. I myself know it. It's a really difficult proposition.
But, if it is a lay person, it is fine, sir. He is a qualified practitioner and he stood.
Not even then, my lord, kindly appreciate one thing. Let us not.
Thereafter also, this man, this person, learned person, he went and filed at Article 32.
He filed it, it was dismissed at the basic stage. Now, my lord, there are several judgments.
All right. Your point is very simple. There is no delay because the selection board's decision was subject to the outcome.
Gotcha.
And the Supreme Court disposed of the petition only in the March 2014.
16 minutes, right?
25th March. Filed by the West Bengal Judicial Service, page 314, 25th March 2014. Then he moved Article 32 in 2016.
Gotcha.
So between there is another 1.5 years or so. Then it was dismissed on 11th of January 2016. Thereafter, after 1.5 years, he filed it. 2 years he filed this.
Now, pursuing a wrong forum also, my lord, your lordship will consider?
No, not in the case of a lawyer and how it's a wrong forum. Suppose he had gone before, let us say, the tribunal or filed a civil suit. That is fine. A normal person. He is a qualified.
No, let me make a very humble submission.
Now where is he? Is practicing here?
He is now, I think, a law officer in the KMC. But the question is, my lord, whether a
should
wrong
do something about the contracts entered by KMCs. No, all staff are on contract. In fact, where is Mr. Mazmundar is not here. He is not registered under the Contract Labor Act. If he is not registered, prosecution has to be initiated. And they have renewed his contract for 3 consecutive terms of 5 years, 5 years, 5 years. I don't want to mention the name of the contract. Your client will know.
He must be knowing because he's working.
20 years, 15 years.
But my lord, here.
So this is a short issue. We
now,
thought that some specially assigned matter.
No, specially assigned because my lords, this matter was actually in the lower this thing list. Then probably your lordship had said that
yes,
these matters.
Because 4 matters was. I asked the court officer, what is this specially assigned? Then they showed the order. I said, specially assignment, it should precede.
Yes,
the other matter.
That's right. That's
Otherwise,
right.
why
I'm grateful. That's why, my lord, your lordship is hearing the matter because it's a very old and a long time pending matter, my lord. And all the courts have released the matter at one juncture or the other for some reason or the other.
I have never done that in this 14 years, except for one occasion, which when we meet in person, I'll tell you, not in open.
No, but my lord, I'm grateful to your lordship. My lordship will kindly consider one thing, whether such a wrong perpetrated should be allowed to continue when no right can accrue to those persons who were given such wrongful benefit. Lord, there are several judgments. Now they have an appeal against this order. The High Court administration has come to save the situation, as I can understand.
No, on that observations.
Yes,
that's Mr. Carr was saying that the court has made certain observations on that.
But those are on the basis. Records are here, my lord. Your lordship will see the records.
No, whatever is the outcome of their appeal, it's not going to affect you. Ultimately, the learned judge, that's why when we read the order, we thought the learned judge had proceeded to set aside or say that the resolution itself of the board was not improper. But it says that and just leaves
stops it at there and goes on to the story of delay. Now, I would beseech my lords to consider and pass that order. The entire action is bad. No doubts about it.
If it is held that reasons have to be assigned, and if reasons have not been assigned, then the entire thing should go.
I'm on that, Lord. I'm grateful, my lord. So therefore,
so the issue would be whether the board assigned reasons or whether, in fact, let us go back to the order passed by the learned single bench. Please come to page 427.
427. Yes.
The minutes of the meeting of the selection board are silent about the reasons for such relaxation. It has not given any details about the representation. It has taken into consideration or their contents. It merely says various representations were made by some unsuccessful. Thus, the High Court exercises power of representation made by unsuccessful. Competent, there is hardly any scope for selection board to exercise the power of relaxation on representation by unsuccessful. In fact, there was no question of making any representation by an unsuccessful candidate, far less for the selection board to act. Decision to lower the pass mark by more than 2 is not informed with any reason. Should have mentioned why they decided to lower the marks in one subject or aggregate, or why should unsuccessful call. No provision unsuccessful make a representation should have not appreciated the vision. Exercise of power of relaxation on the basis of representative made success might have been relevant if the advertisement contained any provision for the same. In fact, some unsuccessful representation appeal a discretionary power of relaxation exercise without recording reason. High Court administration produced a copy of the representation. Unsuccessful candidate made a grievance that in spite of having lower marks in other papers, lower aggregate other papers have been qualified and they got pass marks in all subjects. So that appears to be the representation. The request to Honorable Chief Justice to consider the case of the ends of justice as 1 mark in one paper, aggregate some of the quality. Or some of the failed to secure minimum should have been lowered the eligibility. All more than had the number of quality will be less than the vacancies.
This is also very important.
Thus, that takes us to the consideration far more. Why should the selection board constituted for conducting or that matter any selection dealing with public game must invoke the power without recording reasons. Order middle of that page 432. Yes. Order is entirely an unreasoned one. Never seeking to record a why relaxation from the stipulated pass mark. High Court administration certainly answerable why 2 marks were lowered, not 1 mark or 3 marks. Where the selection board has not been mentioned. After taking into consideration so and so, no recording of reasons, why relaxation? Where is the compliance of the requirement recording reasons? Even if the advertisement it was mentioned that the right to relax the eligibility criteria could be exercised, it is settled principle of law when a power is given to an authority to be exercised only if that was required, such power cannot be exercised. selection board appears to have not. The selection board has been indicted.
Yes. No, because the entire action is because of that. And the funny thing is the courts every day throw out such action by the authorities. But the courts themselves have done this. The selection board comprising of, as your lordship said, that he is a advocate, he knows everything. So the persons who are in the selection board, what more can I say, brother?
In fact, up to 435, everything is there.
Yes.
Then the court at page 436 says, this being the conclusion of the court on merits of the case, it is necessary to consider the relief. That's where he got.
And then at a tangent or rather reversal. Now, Lord, I would beseech your lordship to consider this aspect of the matter. And the other aspect, my lord, if the action taken is bad, and if I have tried to continuously come before the courts for the purpose of getting redressal, whether the act perpetrated would give any benefit to those persons who will continue to serve by virtue of such illegality. It is not an irregularity, it's an absolute illegality.
How many such candidates were given this mark?
I think what 3 persons.
2 candidates.
4 candidates, 2 qualified.
Totally 4 candidates, relaxation was.
A relaxation was given.
Another one to be qualified. And there are 2 candidates. One is now
Here. So 4 candidates were given relaxation, or rather additional marks. How much? 1 mark.
respect of my case 1 mark, respect of the other candidates.
Up to 2.
Up to
Because the
maximum.
decision was up to 2.
So he has not implemented the 2 mark candidate.
Yes, yes. We will implement everyone.
They said it was that candidate was from the repeated competitive examination. So therefore,
Not from the bar.
so therefore, but the this goes that was.
But respondent number 4 and 5 are the private respondents. And 5 is no more in the world. 4 is there.
He passed away. Examiners. Yes, sir.
Now, Lordship would be pleased to come to the power which was exercised, the relaxation. Page 46, volume 1. The advertisement starts at page 43. One.
Yes.
Lordship straightaway goes to page 46.
Yes.
The bottom portion, the High Court reserves the right to relax above eligibility criteria and qualifying marks in each subject or aggregate if required. In my humble submission, there was no requirement because there were sufficient candidates. And
in fact, whatever observations have been made by the learned, the honorable single bench, that can be your argument.
It is, my lord. And I proceed forward to say that there should be no.
Because of that, the entire thing should have been set aside.
That is what I would beseech my lord to consider.
We will consider.
There are several judgments, my lord. I don't think that is necessary to be quoted.
Not required.
My lords. But this is the crux of the thing.
But reading through the order, we found that the full court has approved this. decision.
That's right.
The High Court is approved.
But you know, Lordship will also think this way, that sometimes it happens, a decision.
Probably that is why he moved 32. That is why he went
Though
to.
personally, my lord, I believe Article 32 is not for service matters. Never entertained. In my experience, I have seen it's never entertained. And they straight away say, go back to the High Court. That's the one and only refrain which occurs.
Probably at being in that mental state of,
yes,
somebody might have said, no, you don't.
Go to the highest forum.
Go there.
That's the thing. Go to the highest forum. You will not get relief over here. Maybe that was the reason. And in fact, Lord, the Reed Court has not given me relief in spite of this.
But what can the clock be set by? What to do now? After so
Lord,
many
there
years?
should be post. Without affecting anyone, if the post is given to this writ petitioner, appellant before my lord, without touching anything else, subject to my lord's approval. And that your lordship can always consider. In fact, it was being considered by the writ court at one stage.
Yes. Yes.
I'm grateful.
First is, my lord, I made a application.
You are for the fourth respondent.
I am for the fourth respondent. Application on 2 counts. As the writ petition should have been dismissed. My lord, kindly takes up, my lord, the thin paper book, supplementary paper book. Yes. The prayers of the applications are at page 25. This application has also been disposed of while dismissing the writ application.
Page
532, internal page 25 of the application. That is my application before the Honorable Single Judge.
Oh, the fourth respondent filed an application.
Yes, because at relevant point of time, the situation.
GA 1608.
Yes. First prayer, there were 2 prayers of
page 508.
No, page, yes. 508 is the 532 is the prayer.
532. Yes. Dismissing the writ petition holding the same not maintainable. In view of the dismissal of WPS C number so and so, being referred to the article so and so, praying for the same relief, holding the interview barred by res judicata.
Yes.
Yes. Dismiss the writ petition on the ground of delay and laches.
That is next part.
Second part.
Now, lordship kindly comes to page 548. That is running page 540. This is the order by which the Honorable Supreme Court was pleased to dismiss the Article 32. Now, lordship will notice this is not SLP. This is not a leave that we are seeking. This is Article Substantive Writ Petition, Article 32. Until there is a leave granted by the Honorable Supreme Court, this cannot be touched. We are not inclined to entertain this writ petition, which is dismissed. Now, lordship would kindly see what were the prayers in Article 32. Prayers are at supplementary paper book, which I have filed. A paper book. Yes, that short one. Article 32 starts from 684. Page tower. The supplementary supplementary.
834.
684.
684.
This is the Article 32 petition, which we have bought on record. Prayers
One second. Page.
Prayers of Article 32, page 737. স্যার একটা ডিস্টার্ব করিস না উপর দিকটা আমাদের।
Page 600. Yes, page 737.
Yes, these were the prayers of Article 32. Issue a writ, order, direction, nature of certiorari against the respondents, herein by quashing the notification dated such and such, issued by the respondent number 1, whereby 3 candidates were called for vivacity personality test, despite not having secured minimum marks of 40 marks in the written examination to the post of district judge entry level by way of direct recruitment from the bar in accordance with the advertisement dated such and such, on the ground that the said notification violates the fundamental rights of the petitioner guaranteed under such and such. Thereafter, direction in the nature of certiorari against the respondents, hearing by quashing the final result dated nil of 2009 in the written examination to the post of district judge by way of direct recruitment from the bar, which was not declared in accordance with the advertisement dated such and such, issued by the respondent number 1, on the ground that the said final results by way of notification violates the fundamental rights such and such. And the order, direction, nature, certiorari against respondents by quashing the minutes of the meeting dated 9/9/2009 of the selection board for appointment of the cadre of the district judge entry level in the West Bengal Judicial Service by way of a direct recruitment from the amongst the bars of the bar, on the ground that the said minutes of meeting violates the fundamental rights of the petitioner guaranteed under such and such. Now, Lordship would, other reliefs are also there. I'll be placing the entire thing. Directions in nature of certiorari against respondents, herein by quashing the notification dated such and such, issued by respondent number 1, whereby 16 candidates were recruited additional district and session judge by a direct recruitment from amongst the members of the bar, and the same notification included 2 candidates who did not secure minimum qualifying marks to be called for vivacity personality test in accordance with the advertisement dated such and such, issued by, on the ground that the said notification violates fundamental rights. Direction in the nature of mandamus against respondents herein, as well as the respondent number 2 to appoint the petitioner herein to the post of district judge entry level in accordance with the terms and conditions. So these were the prayers which was dismissed by the Honorable Supreme Court. Now, my lord, in standards of SLP will not be applicable here, because SLP is leave to file. If that is dismissed without any liberty, other remedies can be availed upon. But this is direct. There is a minute difference between 32 and SLP. Learned senior friend had submitted that there are catena of decisions which says that SLPs dismissed at the preliminary stage would not create any. I admit that. There is no doubt with regard to it, but
without reasons,
yes,
it will not operate as res judicata.
Yes, but here it will. Direct, because it is Article 32.
That is at page 548. No?
540.
We are not
Yes,
inclined
yes.
to entertain
540. This is here also. I have annexed it. That is annexed in this paper book also. That will be at 653. In several places it has been annexed.
Yes.
Now, Lordship would compare the prayers in 32 with the prayers in the writ petition, which has been dismissed. The prayers are at page 35 of volume 1. Page 99.
Page 35. Yes.
These are virtually the similar prayers, couched in a different language, but the memos which have been challenged are same. That's minutes dated 9/9/2009. Thereafter, the process dated 28th October 2009. They're substantially the same. And thereafter, the substantive prayer of appointing the petitioner as the district judge entry level.
That is prayer F. Page 37.
Yes. Now, our next point is knowledge. Whether knowledge and estoppel. Lordship may kindly sees. No, supplementary. Kindly, my lord, takes up volume 2. The main ground of dismissal is the delay and laches. Learned senior friend has made a submission that he didn't had knowledge and he had given an explanation till 2016 when the SLP, this Judges Association SLP was dismissed. My humble submission before Lordship would be, it was totally in his knowledge when he had participated in the recruitment process post vivacy. So therefore, having participated in the recruitment process with his eyes wide open and knowing that the persons have been given 1 or 2 marks grace, he cannot now turn around and challenge the subsequent part of the recruitment process.
Yes.
My lord, kindly takes up the affidavit of the private respondent at page 272. Kindly comes to paragraph number 4, where I've quoted the relevant part.
Yes.
Paragraph 4. I say that in the writ petition, the petitioner has deposed in paragraph 8 and 9 that after declaration of the results of the written examination on 21/8/2009, the statements of the writ petitions are as follows. To the utter surprise, and a notification dated 28/8/2009 was thereafter issued by the respondent number 2, whereby 3 candidates who had not qualified on the basis of the written test, namely such and such, such and such, such and such, were called for vivacy test. So this is the pleading in the writ petition. Next paragraph, kindly sees. In my affidavit in opposition, I have deposed in paragraph 8E that such petitioner, that since the petitioner has continued to participate in the recruitment process without any objection and had appeared in the vivacy and waited for the declaration of the final results and the notification of posting in respect of the successful incumbents from the bar published in 28/10/2009, the petitioner is stopped from challenging the recruitment process or any orders passed in the recruitment process. Now, my lord, I have quoted, my lord, how the petitioner has dealt with these submissions in the paragraph in reply. Petitioner, after perusing the affidavit in opposition, had in his affidavit in reply stated in paragraph 4 as follows. In any event, after the publication of the result of written test on such and such, showing that I had cleared the same, secured 13 position on or around such and such, I received an intimation by speed post requiring me to appear before Vivavacy, and there was no occasion for me to scan the website till the Vivavacy was over and final result was published around. So therefore, he is avoiding the website. That is his stand in the reply. Now, kindly, may I place, my lord, the list of candidates qualified for Vivavacy personal test for appointment to the cadre of district judge in West Bengal Judicial Service by way of a direct recruitment from the bar, along with judicial service by way of a direct recruitment from the bar, along with time and date for Vivavacy being impugned, notification dated such and such 28/8/2009 was uploaded in the official website of the Honorable High Court on 28/8/2009 itself, as would be appearing from the website even as of today under the heading notification. This is as of today appearing. However, the notification number which may be erroneously displayed as such and such should be rated as such and such, which is being downloaded from the official website if such heading is clicked. Now, my lord, kindly comes to the screenshot and the website. Screenshot is at page 277. Kindly see the middle part. List of candidates qualified for Vivavacy personality test for appointment to the cadre of district judge and judicial such and such service by way of a direct recruitment. This was uploaded on 28th August 2009.
Yes.
4 p.m. So, petitioner cannot deny knowledge. Now, my lord, kindly see what was said. Next page. This is the notification which is sought to be impugned. It is hereby notified that the Honorable Selection Board, after considering the various representation made before the board, has further been pleased to call the following candidates who have obtained 2 marks less than the pass marks fixed in any subject or in aggregate for the Vivavacy personality test. The date, time of the test for respective candidates has also been mentioned. Each of them, the Vivavacy personality test will be held in Calcutta High Court. Intimation to the following candidates will also be issued separately to speed post. The following candidates are requested to register their attendance half an hour before the such and such. The names of the candidates are there, my lord, who have been granted 1 or 2 marks. In my case, the last name is mine. And kindly do not turn the page. Now, my lord, my humble submission before a lordship would be, lordship has turned it. My humble submission
Make
before
your
a honorable.
submission, sir. What we have to do, we will do. Whether we turn the page or we put your paper book upside down, we will decide. So,
my humble
according to you, as on the page 278, as on 28th of August 2009,
yes,
when this appellate side notification was issued, he was aware that
yes,
6 candidates, 3 bar candidates, 3 service candidates were given this grace mark.
Yes.
Or whatever exemption something.
So,
and according to you, website it is loaded on 28th August.
Itself.
He says in his affidavit you have quoted, no? He says on 27th he received the speed post.
Speed post, but this was in the website. He cannot deny website.
Nowadays, they know most of them are not worried whether they are selected or not.
Yes.
They see the website to
Always,
find
yes,
out
everything.
who else is selected.
Now, my lord, these on the previous things are also being done in the website. It was there. It is just not very far away. 2009.
Oh, a small digression, Anjan. Mute.
where without filing, where
have
we have
noted
not
your-
filed caveat, my lord, we were able to see the physical list and go and appear and
Yes,
say.
yes, we have to check the register, caveat
Yes.
register.
We didn't have the caveat, but
No.
seeing in the list, we went and said that we have not filed caveat, but kindly hears me in respect of admission of appeals, first appeals and such and such. But my lord, this, since your lordship is, my lord, we do not get opportunity to address, my lord, on these issues. Previously, pre-COVID, the supplementary list used to be like this. But post-COVID, the supplementary list has become like this in view of the fact that they print as it is what is published in the website.
But our supplementary, our daily list is only this much,
Yes,
only 3
but my
pages.
lord, previously, lordship, the Honorable Justice Bhattacharya will be able to, my lord, assist your lordship on this. We used to get supplementary lists so thin, it was very easy to handle, it was very easy to work out because it was indicated
All right,
there.
then consider going, we will
Yes.
dispense with printing.
No,
Yeah, but minimum copies we can make.
No.
To the Bar Association.
Dispensation of printing will not be required if the my lord, thickness of the list is.
We are working on that, let us see.
That
All
is
right.
our representation from the bar also.
Yes, yes, all of you will be heard.
So
So
therefore,
according to you, he had knowledge.
Yes.
So he had knowledge, but he filed the, what is it, impleading.
Yes, he has. So therefore, from August 2009, he is having knowledge. 2018 is the writ petition. So we have to set back the clock from 2009. 9 to 18, it's nearly 9 years. That would be substantiating the reasons of the Honorable single judge in dismissing only on the point of delay and laches.
Where is the list of dates?
List of dates, I think, is in volume number 1.
Volume 1.
Page 6.
It is here. Lordship's court.
Hmm.
Administration. I had filed not a written submissions. But that contains an exhaustive list of dates.
Okay.
Should I have a copy?
We please call. Huh? So this IA 6 of 2010 was filed before the Honorable Supreme Court.
Yes.
It was sometime in during 2010. That was dismissed as not pressed in 2011. Then recalling application filed in 2012. No, when it was filed, we don't know, but it was dismissed on 23/7/2012.
Yes. Orders I can give one of the pages.
Date of filing the recalling application is there.
I have annexed the recalling.
You just give the date alone.
Recalling application.
At least a month.
Yes, yes. I'll just not pressed. Just. This is filed in April 2012, page 645 of this A4 size paper book. Yes, this is the prayers of the recalling application, and Lordship would see
April 2012.
2012. 645. So 2012 recalling application dismissed by order dated order ta work.
23rd July 2012.
Where is the order? Where is the order? এখানে অর্ডারটা লাগানো আছে। আমার লাগানো আছে। একটা থেকেই আমরা পেয়ে যাই। না 143 এখানে আছে।
In fact, we saw that order.
149 volume.
It is also annexed here so that Lordship can trace out from
preferably you stick to one.
Yes, one paper book. That is why. Yes, yes.
That's it.
I'll just find it out from this paper book itself. Yes, page 826 of this A4 paper book. It is annexed there. So Lordship takes one paper book itself. 23rd July 2012. Application is utterly misconceived and is dismissed accordingly.
Page 149. This application is utterly misconceived.
Page 149.
And this is equal to page 826 of this A4 size paper. আমি এটার থেকেই দেখেছি।
Yes.
So therefore 2 points.
Knowledge and estoppel.
First is Article 32, direct res judicata. Second is knowledge. And my lord, we addressed the honorable trial judge on merits. But my lord, in any case, since learned friend has not addressed on merits, I will also not address. I think
on merits, that is a different argument.
Yes, that is a different
argument. It is beyond your scope. On the thing, whether the administrative board, etc. Probably you can toe the line of
that is
senior advocate, whatever.
Senior will come to
our learned advocate's argument itself is the reasons given by the learned judge.
Yes. No, Malad, I cannot go beyond this.
Yes,
that is
better.
Deep law.
Yes. Yours is a separate appeal. Cross objection, correct.
The findings of the learned judge on the issue with regard to the administrative authorities' action, which I say the court had no jurisdiction to go into, because if the writ petition was itself not maintainable, the court could not have scrutinized the factual issues at all. Lord, I had raised 5 points on maintainability. I'll just tell your lordship those points. The first is that stale claim. That's my first point. The second is forum shopping. But the third point is cause of action estoppel. Fourth is, having participated in the selection process, he had waived his right, because my contention is that he had full knowledge of the facts, because everything that happens is put up in the website of the High Court. And the last point was, of course, res judicata, because my contention was it is res judicata in both ways. First is, Lord, issue is finally decided, and it is also barred under Order 2, Rule 2, because, Lord, when the Supreme Court dismissed his application under Article 32, Supreme Court did not give him leave to move the High Court.
No.
It was on the self-same cause of action that he had filed the Article 32. And your lordships have seen the order
Yes, we have seen
under
that.
Article 32. So, my lord, insofar as res judicata is concerned, I said that it has reached a finality once, my lord, the Supreme Court has considered this. Now, my lord, the judgments which I cited, I don't want to repeat those judgments. These are all part of my written submissions which I filed. I'll just, my lord, make a note and give it to your lordship, because my learned
The same submissions you can give.
same submissions I'll just file it before your lordship, my lord. By tomorrow morning, I shall file it. So, my lord, these are, my lord, on the question of maintainability, these 5 points. Now, my lord, because by the time I entered the matter, the learned judge was well into the facts, production of file, looking into the papers, etc. So, my lord, those at that stage, when I entered the matter, I obviously, my lord, I had to address the court on merits. Lord, I say that on merits also, he cannot have an objection, because the lordships may kindly have a look at the advertisement first. Just page 43, first volume.
Yes.
Now, your lordships may kindly come to page 46.
Yes.
Kindly, Lord, come to the second last paragraph.
Yes.
Lord, your lordships will find it says the High Court reserves the right to relax above eligibility criteria and qualifying marks in each subject or aggregate if required. Now, Lord, what had happened is this: in the High Court administration's affidavit, these facts were disclosed. The lordships may kindly come to page. No. Page. Kindly give me 100 and no. Sorry. The affidavit in opposition was filed. Just wait. It starts at page. Opposition of the High Court starts at page 162. Your lordships can kindly come to page 162 and take note page 181. 162.
In this list, they have relaxed. Yes.
If your lordships kindly come to page 181.
180.
181.
Volume 2.
Second volume. Lord, the roll numbers are there in the chart. Please take, Lord, the second last name in page 181. Lord, on the right hand side, your lordships will find the percentage of marks that each of these candidates have got. So, Lord, the percentage of marks is on the second last column. Your lordships will find that these are the percentage of marks that one got. But not there. It appears that the second last candidate had not passed in one subject. That is second subject.
38.
Yes.
Minimum is 40.
40. But Lord, this he had secured, Lord, percentage wise, he had secured a higher percentage in rank. I mean, this was one case. And the second case, your lordships will find, please turn the page. Please look at Lord, serial number 155. The percentage of marks is on the right hand side. Again, Lord, in the second subject,
1 mark.
But
But secured 52.6. Yes.
And
where is the writ petitioner?
Writ petitioner is, kindly come to the third name from the top.
Yes. Serial number 011, roll number.
Yes. This is not in regard to the written examinations. This is not in regard to written examination.
Exactly.
So that Lord, there was
Yes, yes.
IOC, and this is with regard to the written examination. So Lord, what had happened is that Lord, percentage wise, whoever received whatever percentage, that was retained. This additional mark did not Lord change the percentage of marks that the candidate had got.
So far as percentage is concerned, he secured more percentage than the fourth respondent.
One of the respondents.
One of the respondent.
But Lord,
but lesser than the respondent who passed it.
Correct.
Fifth respondent.
Absolutely. Lord, kindly see page 186.
Yes.
Lord, what happened was, after all, Lord, the selection board, which sets the question or invites Lord candidates for written examination, they also know that which are the papers, how it has been set. They are the best judge of the whole situation. Now, Lord, this is not the decision of the minute. This is the minutes of the meeting of the selection board. Has your lordship found that? Page 186.
Yes.
Says, after taking into consideration the various representations made before the selection board by some of the unsuccessful candidates, the selection board unanimously resolved that any of the candidates who appeared in the examination for recruitment in the post of district judge entry level, either by way of direct recruitment from amongst members of the bar or from category of limited competitive examination from among judicial officers, has obtained 2 marks less than the pass marks fixed in any subject or aggregate, they may be called for vivabucy. So, Lord, when they decided this, they were not acting without jurisdiction, because, Lord, in the advertisement itself, it was indicated that this power is retained by the selection board. So, Lord, this decision is taken by the selection board. Then, Lord, please turn the page to 187.
Yes.
This is not the lay note, which was placed before the Honorable Chief Justice. Kindly, Lord, come to the second paragraph. I beg to submit that in the said minutes, the Honorable Selection Board was pleased to resolve that all the candidates who appeared in the examination for recruitment in the post of district judge entry level, either be by way of direct recruit amongst members of the bar or from category of limited competitive examination from amongst the judicial officers, has obtained 2 marks less than the pass mark fixed in any subject or aggregate, they may be called for vivabucy. Your lordships approving the minutes may be circulated amongst the honorable judges in the High Court for kind information and comments, if any, and if no comments is received by tomorrow 1:15 p.m., then it may be deemed to have been approved by the full court. Then, Lord, please turn the page 188. Kindly come to the second paragraph. Pursuant to your lordship's order, the said minutes of the selection board was circulated amongst the honorable judges of the High Court with request to express their lordship's comments. It is humbly submitted that no comment in this regard has been received. by the office till 1:15 PM this day. In view of the above facts and circumstances, Lordship approving minutes stated such and such, Board of Recruitment, by way of direct recruitment, members of the bar, etc., may be deemed to have been approved by the full court by circulation. So, my lord, after this, the notification was put up for the purpose of the viva voce test. And pursuant to that, the viva voce test was held. Result published. Now, my lord, interestingly, I just want to give your lordship 1 or 2 dates. Because, my lord, after the results were published, then there was a decision by the selection committee that panel up to 18 candidates will survive till declaration of vacancy for the next year. And then the posting orders were issued. On between 20th October 2009 to August 2011, these posting orders were issued. Now, my lord, in the meantime, on 9th of April to, I'm sorry, August 2009 it should be. My mistake. Then, Lord, 9th
The posting orders were issued between 20th
October 2009
to
must be August 2010. August 2010.
Must be 10.
Yes. Then, Lord, in the meantime, on 9th of April 2010, advertisement were issued declaring 23 vacancies for direct recruits. This is the next year's, Lord.
So that wait list got lapsed.
And then, Lord, what happened? Up to this 2012, your lordship has seen that there was no movement from the writ petition.
No, he went to Supreme Court.
Yes. Kindly see when he filed the first application before the Supreme Court in 2011. 2010. That was, Lord, when the subsequent year's vacancy was declared. And this application that he had filed had nothing to do, Lord, with the selection that was made by the High Court.
He wanted himself to be implicated
in that pending, Lord, Malik Mazhar's case, which had no connectivity to the selection process.
So this application itself, according to you, was issued after the fresh notice. 23 vacancies were notified.
Yes.
So therefore, the reserve list or that 18 candidates pool lost its. How many candidates were accommodated?
I'll
No, it will be here.
It is there in the affidavit.
16 candidates.
16. Now, Lord,
Lord, may I just, there is one thing, Lord. The selection board had said that would abide by the result.
Abide by the. That is Malik Mazhar. That is standard fitting. All the.
Correct. And Lord, just one date for your lordship's, Lord, record. This recruitment of 16 posts were also pursuant to an order passed by the Supreme Court on 13th of January 2009. Please come to page 58 of volume 1. Lord, I will give your lordship, Lord, in the notes itself, there is exhaustive list of dates with page number.
No, you can just give a photocopy of that.
Yeah, we will do it.
Fresh notes.
By tomorrow morning, we shall hand up.
Today it can be done.
Yes, today itself can be done.
Only thing is old notes, no new notes at all. Slightly. Already there are 4, 5, 6.
I'll only to give your lordship because, Lord, I don't know.
No, we have taken notes, but still chronology is there. Page 6 of volume 1, it's there.
Page 58.
Yes.
If your lordships kindly look at, kindly come to page 59. The respondent number 1, Registrar General of High Court is directed to furnish the details as to how many vacancies of post of district judge had fallen vacant prior to such and such, the date of commencement. The High Court will also furnish details as to how many posts were filled up, etc. Then the process for filling up of 16 posts of direct recruitment had already been undertaken by the High Court, and further steps can be taken for effecting the appointment of the candidates who are selected by the West Bengal Public Service Commission. Now, look, after all this, look, 2012, 23rd July, his recalling application is dismissed. Then, Lord, he files an application, files a writ petition under Article 32. That got, Lord, dismissed, Lord, on 25th of March, 2014. Now, Lord, that your lordships will find. This is at page 150, 151. Your lordship had taken note of. I did not, Lord, say. It is not, Lord, a simple dismissal. The Supreme Court has given 1 or 2 sentences in addition to the order of dismissal. Your lordships will take note of that.
We are not inclined to entertain this writ petition, which is dismissed.
So, my lord, it is not on the ground of maintainability. It's just basically, my lord, on the merit. The Supreme Court was not inclined to entertain. And Lord, the prayers are at page 737, volume.
Yes, we saw. Learned friend has pointed out, saying that he said it's more or less identical. Language is different.
Absolutely same relief, and based on the same cause of action. That is, Lord, 2009 selection.
Yes.
So, Lord, apart from the delay, Lord, there was a question of forum shopping also, because he tried his luck before the Supreme Court first.
He was not confident here.
Obviously. Obviously.
Poor fellow.
This was a second thought litigation, a fallback. And Lord, I only say this, that grant.
He probably. Court has taken a decision. But one subtle distinction which is because that is an administrative.
Correct.
So many administrative decisions are set aside in the judicial sector.
Absolutely. Possible. Possible.
Happens.
It is possible. But Lord, today, kindly consider that insofar as one of the respondent is concerned, he was above him. Percentage-wise, he was nowhere near.
Correct.
So therefore, that question could not have been gone into by the court, any court going into the merits of the matter, even if that is the issue. Now, Lord, grant of 2 marks. As I said, there are many times, Lord, when the question papers are set by the person, Lord, who set the question, he might think that this was a tough subject. And Lord, the selection committee taking a decision to grant 2 marks, that itself can't be a cause of action for the purpose of a litigant coming to court. Because, Lord, he has to show that it was so arbitrary. Unfortunately, when the matter writ petition was filed in the High Court, Lord, none of the honorable judges were present. So, Lord, the selection committee could not, Lord, even I mean, the High Court administration could not take assistance of the selection committee for the purpose of understanding the nuances of or reasons for this additional mark that the selection committee itself thought. And it was a full court decision. Or
yes, it's a full court decision.
It's a full court decision.
There is no dissent means it's a full court decision.
And therefore, Lord, it can't be said that there is no reason, etc. The court is saying this after 12 years. Without, Lord, calling upon the whatever papers were there, the High Court administration has truthfully, Lord, placed it before the court.
How much was the marks assigned for Viva OC?
Viva OC, I'll tell you.
Percentage. You see the notification? Sir, where is the notification?
Notification is page 43. 100 marks. For vivacity and personality test. Lord, please come to page 43. At the bottom, the pass mark on each subject will be 40. And in addition to that, the candidates must obtain 50 on aggregate in order to be successful in the written test, and further 100 marks are reserved for vivacity and personality test. The pass mark for vivacity personality test will be 40. Then
so 40 in the subject will be minimum, 50 in the aggregate, 40 minimum in the viva.
Correct.
So admittedly, all the candidates secured the aggregate 50.
Absolutely. Aggregate, there was no change in the aggregate.
Even those, the other three.
Yes.
The 3 from the bar, 3 from the service, all 6 candidates secured 50 in the aggregate.
Correct.
Above 50 in the aggregate.
Absolutely.
But a few candidates secured 1 or 2 marks lesser than 40.
Absolutely. And
what was the mark secured by him?
Your lordship.
In the viva.
Oh, in the viva. Viva to ache ekta kothao.
Because he says in his
Kindly give me 1 minute. I think that is also there. Vivacity test is also there. Kindly give me 1 minute. Yes. Vivacity test is there.
children.
162. High Court's administrations.
Page 97.
I'm grateful to my learned friend. No, 97 ही है चल. देखो, जो गलत दौर करने के लिए. कितना बजे? 25. এটা একটু জেরক্স করে দিন দুজন করছে আরে দিয়ে দিন please look at page 97.
Page 97.
Yes. The first page, serial number 15.
1 second, 1 second.
Starts at page 96.
96 it's.
We are concentrating on the 2 candidates. Please come to page 97.
We should not see page 1, 96. That's what your friend said.
Please come to page 97, serial number 15.
Yes.
On the right hand side, your lordships will find is the marks of vivacity.
Overall assessment.
Overall assessment.
52 plus 52. No,
Yes.
sorry.
And 52, 3, all 3. And please come to serial number 10 also.
1 second. Marks obtained so and so, so and so, so and so. Average mark of the vivacity percent. A plus B plus 3 divided by 3. Very
Yes,
good.
that is how the percentage is arrived at. Your lordships may kindly take note of serial number 10 also. And Lord, serial number 17.
Yes.
So, my lord, my second part, the challenge is the learned judge, my lord, firstly, unnecessarily went into these facts. If the petition was expressly not maintainable,
That we
question
have
of
noted down.
going into the merits that did not arise.
Not have gone into.
And number one, and number two, my lord, even if he had gone into the merits, the remarks are really, my lord, not warranted in the facts and circumstances of the case. Because after all, my lord, the whole, the full court had not approved of this procedure. And on the lighter vein, Lord, this decision has been in favor of the institution because, Lord, obviously in the future shows post 2009 that many of them have excelled in the service. So, Lord, it was after all not that such a bad decision. Only thing is, Lord, my learned friend, if he had come in time, proper time, then he could have asked for adjudication on the merits. But Lord, if he has been a fence sitter, sitting on the fence for a period of more than say 6-7 years, and then Lord 9 years, and then Lord he files a petition first in the Supreme Court. Effectively, that's his first challenge. Not having succeeded on the rebound, he came to the High Court. And Lord, this is what is not permissible, deprecated over a period of time. And Lord, judgments, I don't want to, Lord, bother your Lordship with it. With my note, your Lordship will kindly take.
So in fact, learned judge has cited so many, referred to several decisions on the ground of delay and laches.
And Lord, most of them were cited by me. Most of them were cited by me. And in fact, Lord, I will from the notes, your Lordship need not take note of all the judgments. Basically, Lord, same point, it is repeated over and over again. Maybe one or two.
Right from 1970 onwards, you have cited decision.
In fact, 60, my first judgment which I cited on the question of res judicata is, Lord, AIR 65 Supreme Court 1150, which said that if you have moved a court, you have not succeeded in getting an order, that's a finality between the parties. This is the first judgment. AIR 65.
All right, you circulate that notes, we will see. Yes, sir.
Reply, my lord, kindly gives me Wednesday 5 minutes. I'll only on 2 points I'll say. One is whether
We will complete it today. Or you want to put some notes or?
Yes, I
then
like 5 minutes on Wednesday.
difficult, sir. The entire list has gone. Whatever we can do is, he can also give the notes. You can give the notes by Wednesday. You add whatever reply submissions also. We have taken 10 pages notes.
I see. Well, only my humble submission would be this. One is that whether the Article 32 petition would debar me from this. This is one point I'll be taking. It does not, in my humble submission. The other thing is that if a fraud has been perpetrated by the act of the authority of the selection board, I'm saying fraud, my lord, with this because it is a legal fraud. Then limitation would have no effect because of the old adage, fraud vitiates everything and the line of judgments.
That appears to have not been argued.
Well, we did.
The learned single bench has not.
No, because
It is not in his pleadings. How can he argue?
No, it's
Not in his pleading.
I'll show you, Lordship. One paragraph.
Fraud has to be pleaded with some particulars.
One paragraph. Lordship, kindly just let me just read that portion of the order. Lord, it's there.
Page number?
Page 17, 16, I'm sorry, page 16.
Volume 1.
Volume 3, page 437. Inner page 16 of the order.
437. Yes, sir.
And the point is, my lord, because it's a pure question of law. Fraud vitiates everything, my lord. It's a pure question of law.
But first it has to be pleaded.
437. No. I'm sorry. That was, my lord, that unequals have been treated as equals. That portion is there.
That portion is
now.
That is
So pleadings with regard to fraud.
I don't think so, sir.
There is no pleading of fraud.
I shall check. No, question is, my lord, if the
No.
Fraud is to be pleaded specifically.
In that one decision, page 437, Mr. Samantha further relied on Kabir data zones. So single judge observed. Come over to 438, middle. In so far as servitudes are concerned, where it is alleged that the aspirant for the post has practiced fraud on the employer to obtain public fraud is found in nature, vitiating the entire group.
So argument was there, Lord.
No. You referred to the judgment. Sir, this is a very serious issue. No. With your standing, you shouldn't be making that. You cited a decision where an employee aspirant commits a fraud on the employer, vitiates it. We accept the legal proposition. Fraud vitiates every solemn act. There is no issues on.
Kindly appreciate what I'm
Sir,
trying
you
to
make
say.
your notes, all of you make your notes. And don't make your notes as big as 3 pages.
No.
We have heard Mr. So and so.
Before rising, my lord, may I have your lordship's leave?
The learned advocates, the learned advocate for the appellant and the learned advocate for the cross objector are at liberty to file their brief notes on submissions, preferably not exceeding 3 pages. The same shall be filed by close of by Wednesday. The learned advocate for the private respondent is at liberty to place few judgments which he seeks to rely on.
Obliged, Your Lordship.
Few days back, my lord, I have missed the list item number 2, my lord, that is in the appellate side, my lord. My lord, kindly, my lord, pardon me, my lord, it's a very unfortunate affair, my lord. After attending 50 years practice in this honorable court, my lord, I have missed the list, my lord, here.
No problem.
Kindly restore it, my lord. It has been passed for non-prosecution, my lord. Your lordship's kindly, my learned junior was not there, my lord.
If we have signed the order, unless an application comes, we cannot restore. You file an application tomorrow, we'll restore. Suppose we have not signed the order, it will come up under the caption to be mentioned. You check the server. If the order has already been uploaded, you file up 1-page affidavit tomorrow, one application. Sign.
It has not uploaded.
dismiss it for non-prosecution. My predecessors 10 years back also, they are saying none appears for petitioner, none appears for petitioner. What we can do?
Not only one thing, Lord, today is not the date for residuary matter. It is also a residuary matter.
ঠিক আছে রেস্টোর করে দেবে তো আপনার কেন
Before my lords rise, Lord.
I'm grateful.
This is a matter of the bank, my lord. Mr. Saha and Mr. Bachawat.
Ah, yes, yes.
My lord, I am left without any account to operate, my lord. 24th, I have to make the
Mr.
payment.
Bachawat was saying
Yes, my lord. 24th, I have to, my lord, make the payment, my lord.
for salary.
Yes, my lord. So if this could take up on priority basis on Wednesday, my lord, any time, or tomorrow, day after, my lord, any time pursuant to your lordship convenience, my lord.
No, this one is especially assigned, therefore we had to hear it.
I understand, my lord.
No,
With regard to that,
which is your item?
Item 21, my lord. The only urgency and predicament, we'll inform the other side, my lord. The only predicament is I am left without a bank account.
I think you have not appeared in these income tax matters before us. By now, we would have crossed 40. But for this matter. So this list will remain like that. Anjan, don't add application about this. This interest seniority, don't disturb. This will remain at that. And your matter will be 1, 2, 3, 4, 5, 6, 7.
If it could have
It will
some
be item 8.
My lord, that's fine, my lord. As long as it's taken up on Wednesday, it's fine with me, my lord. I'm so grateful.
We will not add anything on top.
I'm so grateful.